has arrived. I request that we rise and welcome him and then get set for the anthems. I'd request the Honorable Attorney General, the Board Chair, and our Registrar General please join us on the podium. This. We'll now have the East African anthem, then we'll do the national anthem. Thank you. We can take our seats. A warm welcome again, ladies and gentlemen. The Honorable Attorney General, Mr. Kiriwa Kiwanuka, Honorable Justice Musa Sekana, Head of the Civil Division of the High Court of Uganda, our Board Chairman, Your Excellency Ambassador Francis Butajira, the Registrar General, Ms. Mercy Kanobisho, participants, both physical and the 350 participants joining us via Zoom, members of top management at Ursb, colleagues, ladies and gentlemen, good morning and a very warm welcome to this second day of the Insolvency Conference. We had our first day yesterday that featured judicial officers. It was a training organized jointly with the Judicial Training Institute. Good morning. My name is Dennis Navende. I work with the Uganda Registration Services Bureau as the Senior PR and Corporate Affairs Officer. I would also like to recognize the presence of senior lawyers in the House, Senior Counsel Andrew Kasire, as well as Don Nyakairu. You're very welcome, and we look forward to having great discussions. To our colleagues outside, just to let you know, this conference is being streamed live on the Ursb YouTube channel. So you can always go to YouTube, search for Ursb, and you should be able to follow the proceedings. I see we now have about 375 participants on Zoom. We welcome you all online. The theme for this year's conference is Emerging Trends in Corporate Restructuring in Uganda, what to expect and how to prepare. The conference is aimed at achieving the URSB's contribution towards the National Development Plan program of developing the private sector through strengthening the corporate rescue framework. It's also focused on equipping judicial officers and insolvency practitioners such as yourselves with the insight into the business rescue mechanisms and legal approaches available to financially distressed companies and individuals, and offering tips on protection of assets and insolvent debtors. The Honorable Attorney General, just to let you know, the audience is made up of advocates. We have CPAs, as well as chartered secretaries. So a quick rundown for the program of the day. We've had our arrivals and registration. We've had the anthems. We'll now go to our third item of the day, which will be the welcome remarks from our Registrar General, who will then, ma'am, I'll ask you to invite the board chair, who will also invite our guest of honor. Over to you, Madam Registrar General. Thank you.
Thank you very much, Mr. Dennis Nabende, our moderator for today's conference. Our chief guest, our beloved Honorable Attorney General, Mr. Kiryowa Kiwanuka, Your Lordship, our Justice Musa Sekana, our very good partner and trainer in the insolvency matters and a renowned judge in commercial aspects. Our board chair, Your Excellency Ambassador Francis Butajira, the members of the board of URSB present, the senior counsel present with us, the members of Uganda Law Society, the accountants and the chartered secretaries and administrators present, our online participants, the URSB team, the media, ladies and gentlemen, a good morning to you all. I welcome you to the 5th Annual Insolvency Conference under the theme, Emerging Trends in Corporate Restructuring in Uganda, What to Expect and How to Prepare. In a very special way, allow me, dear participants, to welcome the Attorney General to this conference. He's been very supportive in as far as implementing the Uganda Registration Services mandate is concerned, and his mandate to this nation. We want to thank you for accepting to be our chief guest. You are the right person that we desired for this conference. We have been informed that there are over 300 participants online. We expect close to 500 online. I know many will be joining in. We want to thank those that have tuned in online to participate in this conference. Colleagues, as you're aware, Uganda Registration Services Bureau is a government agency that is charged with many responsibilities. And our chief guest, you are already aware of these responsibilities that we hold, but allow me to break them down for the participants that are here physically and online. Uganda Registration Services Bureau maintains over 21 registers. I know many people, members of the public, know us famously for company registration, a bit of intellectual property, and a bit of insolvency, but we do much more than business registration, insolvency, and intellectual property. We maintain the register of business names under the Business Names Registrations Act. We maintain the register of companies under the Companies Act of 2012. We maintain the register of documents under the Registration of Documents Act. We also maintain the register of partnerships under the Partnership Act. With regard to intellectual property, we maintain a number of registers. We maintain the trademark register, which is the most utilized trademark registry in intellectual property, and we've seen so many local innovators registering their trademarks, their logos, their scents, their designs and shapes, and so on. We also have the trademark, the trade secrets registry, because it protects secrets of trade that have commercial value. And whereas we don't have the physical registry because the law requires you to keep it as a secret And so your secrets, as long as they relate to trade and have commercial value, are protected by the legal system of the country. We also have a registry of patents, a registry of utility models, a registry of technovations, a registry of industrial designs under the Industrial Designs Law of 2014 and the regulations thereunder. We have a registry of literary, artistic, and scientific works protected under the copyright system under the Copyright and Neighboring Rights Law of 2006 and the regulations thereunder. We also protect geographical indications under the intellectual property system, which is governed by the Geographical Indications Law of 2013 and the regulations of 2017-2018. We maintain a registry of traditional knowledge that is partly under the current copyright system, but we are working with the Ministry of Justice to create a sui generis law that will protect our traditional medicines. You know, Uganda has been strong and continues to be strong in traditional medicine, and which such shows that we could be the country leading in medicinal plants in Africa, if not in the world. So we are gifted, and we need to protect our traditional herbs, our traditional music, our traditional folklore, our traditional assets and cultural assets, because we are a country that has over 65 languages and tribes, and so that is an opportunity and an asset. And the traditional knowledge system does protect all this. Under the security in movable property system, we have that security in movable property register, commonly known as the Chattels Register, that allows movable property to be pledged as security or used as collateral in access to finances. And the 2019 law that amended the 2014 law, which amended the 1978-79 law, is in place and is functional. And on our register, we have so many vehicles that are being used as collateral. And this will it also enables people that do not have fixed property to access finance. And we see so many women benefiting from this system, and the young people and the youth. And all these laws are put for every Ugandan to participate. In the civil registration, we implement a number of laws that relate to marriages. Civil registration, we have the Marriages Act. I know the bill has also been around that will amend and bring the modern and emerging trends in marriages and the whole family arrangement. We have the Hindu marriage system, we have the Mohammedan, and all those laws that we implement that enable the 5 legal types of marriages, including the customary marriages. We have also maintain a register of insolvency practitioners, and we're happy to have you as our insolvency practitioners registered with Ursb. But we also have a registry of trademark inspectors under the trademarks law, and a registry of copyright inspectors under the copyright law. I can go on and on. I bring this to your attention because of the huge mandate that we have for this country. We have achieved great in as far as our journey is concerned. In 2012, if you look at our databases and our systems, our registrations were very low, and even our non-tax revenue was very low. It was at 5 billion per year in 2012. But as we speak, we collect 50 billion every year. And this financial year, we're going to record 60 billion plus. But we have a potential to collect even 300 billion as long as we promote the formalization of the informal sector. You know, Uganda has a large informal sector. The many businesses that you see, you support, you work with, are not registered. And just to give you an example, that our register of businesses has less than 1 million registered companies and business names and all categories of companies, limited by guarantee, public companies, and those that are limited by shares. It is so ashamed to have a register of less than 1 million registered businesses in Uganda, in a country of over 40 million people, but with businesses of about between 15 to 20 million that are being operated within our jurisdictions, within the cities, within the municipalities. So we need to grow our register, and we can only grow our registers with you, colleagues. So let's promote formalization. I know somehow it's not mandatory under the Companies Act to register a company in Uganda, but we want to also move to make it mandatory where they we are advised by the Attorney General, so that we have a formal sector for better planning of the country, but also for the benefits that accrue out of registration. Another great achievement that I would like to register with you, colleagues, is the Uganda Business Facilitation Center. We, as Uganda Registration Services Bureau, through the Ministry of Finance, got support to set up a building in Kololo. This is a 16-story building that will be occupied not only by Uganda Registration Services Bureau, but also the Uganda Investment Authority, the Capital Markets Authority, and all government MDAs that touch the business facilitation. And with business facilitation or formalization, we mean business registration, which is a role of Ursb, the business licensing in terms of trade licenses through the KCCA and local government, the tax identification number through URA, the land registration, NIRA, all these organizations or agencies will be represented in that one-stop center on the building that we'll have and maybe we'll be moving to in May or June this year. So we'd like to thank government. Of course, we are government, but we want to thank government for putting up this facility for you and I, for the business person downtown, for you, the land person, you, the accountant, to benefit from that. You do not have to run around moving out, getting a license from one office to another, which affects the cost of doing business, but also the processes and the time it takes to do your business. And this facility is going to ease the registration and the licenses that are acquired. Mr. Chief Guest, allow me to appreciate the fact that this is the 5th annual conference, and last year we were disrupted by COVID-19 pandemic. But the reason for the theme for today and the reason for gathering here, how do we take note of the emerging trends? How do we survive and support the companies, the businesses that have failed as a result of the COVID-19 pandemic? We're here to discuss the business rescue mechanisms for our businesses that we represent and for the ordinary person that runs those businesses on the street. And we're here making those conversations to get solutions. I want to thank the facilitators for today. I want in a special way to thank His Lordship Sekana Musa, who has been very supportive. We have legal practitioners that are going to take us through various presentations. And in a special way, allow me to thank our staff of Uganda Registration Services Bureau. Please stand up for recognition. Please stand up for recognition. I know this is our duty. This is our duty. But I would like to thank you for the great efforts that you have put here. And in a special way, allow me to pick out the committee that was in charge for organizing this insolvency conference. I do not want to stand here and take the credit. The credit goes to that committee led by Mr. Mustafa Antale, the Director of Insolvency and Receivership. Please approach with your team, Patience, Carol, Sam, Jackie, Immaculate. There's so many. Please come, and we appreciate you. I want to take this opportunity to thank you very much before our chief guest, who is also our boss and our supervisor, for the great work and commitment that you put into the work you do. As leaders, we cannot stand alone and we cannot take the credit. The credit goes to the people that do this work, and this is the team that has delivered to us the 2-day conference of insolvency. I thank you very much, and may God bless you. You may take your seats, please. Our chief guest, I thank you very much, and I say all this for God and my country. Now, in a special way, allow me to invite our board chair. Our board chair is a man of high profile, and I'm not even worthy to read his profile, but allow me to attempt to. Our board chair is Honorable Professor Canon Francis Butagira, who has served our country in many spaces. He was a justice of the courts of judicature in Uganda. He's an advocate of courts of judicature. He was a speaker of parliament of Uganda. He has served our country as an ambassador in many states. He is a canon in Church of Uganda. He's a professor of a renowned university. And most importantly today, he is a board chair that has served and advised and guided us, and all the achievements that are mentioned are attributed to his leadership as a board chair and all the members of the board. With humility, allow me to invite you, Honorable Professor Canon Francis Buchajira, to give us your remarks. Thank you.
Thank you very much, the Registrar General, for introduction. Honorable Attorney General, Mr. Kiryowa Kiwanuka, who is our guest of honor here, and actually the boss of Uganda Registration Service Bureau at policy level. Honorable Justice Sekana, head of the Civil Division, thank you very much for your services, the Registrar General and the staff, and distinguished participants today. I welcome you to this year's Insolvency Conference, organized under the theme, Emerging Trends in Corporate Restructuring in Uganda, What to Expect and How to Prepare. Today's session is for insolvency practitioners, as has been said, lawyers, accountants, policymakers, and representatives of financial institutions. The Board of Directors is principal body for Uganda Registration Service Bureau. As a board, we are impressed with immense milestones so far achieved by Ursb in creating a sound insolvency system. Insolvency has positively grown over the years, and we encourage all stakeholders to work towards strengthening the corporate rescue framework mechanism. As you know, in the past, when a company went under, there was a hurry to bury it. But now, we want to rescue them, and especially medium and small scale enterprises, which form the bulk of our economy. If they are allowed to go under, then we are not doing service to our country. So the trend now and the emphasis is on rescue and not signing a death warrant. As you are aware, insolvency practitioners are key stakeholders in the insolvency ecosystem. Your actions may determine the survival or death of an insolvent entity. It is therefore important that you handle your work diligently and professionally. On behalf of Ursb, I commit to continue carrying out capacity building trainings as this one and similar ones. It is through continuous trainings that we shall be able to fulfill our contribution toward the National Development Plan 3 program. Following the enactment of the Insolvency Act 2011, key provisions relating to arrangements and administration were introduced, which have facilitated corporate restructuring schemes that are legally recognized and even administered by courts. It is important that we discuss these mechanisms so as to improve the investment climate. A solid insolvency regime attracts investors into the country, and effective corporate restructuring mechanism will attract even more investment into the country. Before an investor makes a decision to invest in a country, he assesses how easy is it to start a business and how the system is conducive if he faces financial problems. In fact, if you are an investor, not only do you look on the law governing investment, but also that's allowing you to register your business as soon as possible. But you also look at the law. If should things not fall in place and you want to wind up, what is the efficient system for you to ease out? So these are the two aspects you have to consider. A solid insolvency regime attracts investors into the country, and effective cooperative restructuring mechanism would attract even more investment in the country. I thank the Ursb team for organizing this conference. I also thank the participants who have spared their time to come here. Yesterday, there was a facilitator but was talking online concerning the role of insolvency practitioners. I think you should know about that as we go on, largely because you play a big part in administering insolvency. And how do you relate to courts? That is food for thought. Thank you for listening to me, and I wish you fruitful deliberations. May I now take the opportunity to invite our distinguished guest of honor, the Honorable Attorney General, to address us.
We actually live in interesting times. Allow me to take off my mask. I think I'm far away from most of you, so I'm not a risk to you at this point. But I was saying we live in interesting times because now I'm being called guest of honor at such an event. And it's actually quite interesting every time I get to these events. I even forget. When I was walking in, I was even told where to pass. I was telling one of my colleagues there that a few months ago, I really knew how to get myself around these parts, but now they don't even allow you. So I think as you go higher, they start now realizing that you need more managing. You need more managing. So please, let us manage ourselves. But first of all, let me apologize for not having been here yesterday. But because of what has been going on, it's been a bit difficult. Your Lordship, the Honorable Mr. Justice Musa Sekana, Head of the Civil Division, the Chairman, Board of Directors, Uganda Services Registration Bureau, Your Excellency Ambassador Francis Butagira, board members of Uganda Registration Services Bureau, the Registrar General, Mercy, Kaino Wish, I just call her Mercy because it is what we are used to. Our presenters of today, the URSB staff, advocates present, and particularly Senior Counsel Andrew Kasirye, insolvency practitioners are present, participants both physical and virtual, distinguished ladies and gentlemen, good morning to you all. First of all, let me take this opportunity to deliver my sincere condolences to the legal fraternity and to the country, the entire people of Uganda, on the loss of the Right Honorable Jacob Olanya, who passed on, the Speaker of the 11th Parliament, who passed on just recently. I request members we stand up and recognize him and for a moment of silence. May his soul rest in eternal peace. Before I get into the depth of my remarks, you know, I'm telling you, we are being managed these days. I'm even told what to say because I may be, what I say now is not just what I just said the other time when I was keke, so I need to be careful. But I've been tickled by the remarks made by Mercy and the chairman, which had not come to me before. Today we are talking about insolvency, but like Mercy said and the chairman, there are so many things that URSB is doing now, and I think it's extremely important for the members of the legal profession to really get interested in what is going on. because most of these things are creating opportunities that we did not actually anticipate. She mentioned a very interesting subject, and I've been reading on it. When I first went to the Attorney General's chambers, I actually didn't know much about it, the traditional knowledge process. By the time I got there, the thing was ready, and URSB was moving with it so fast. Like they would say in our local speech, "Bali bantu wala speed." So I first said, hold on, let me first understand this thing. Now, this is an extremely new area, which we have never quite, as a people in Africa, quite thought about. As we grew up, so many things happened around us which were really taken care of naturally by our traditional knowledges and etc. Never written, never taken care of. We had backcloth, because we were not in these clothes before. We had backcloth. There were processes that were used to do that. But no one bothered to register it, and then you find yourself having backcloth registered in another country which cannot even have a tree that can produce backcloth. So this is an area that URSB has come up with, and therefore these huge opportunities that are being created by URSB, I encourage all of you practitioners to really get interested in those spaces, because these are creating new opportunities. It is really an honor to officiate at this year's Insolvency Conference, organized by the URSB, for insolvency practitioners, policy makers, financial institutions, stakeholders, the courts. And the theme this year is actually quite interesting. It's emerging trends in the corporate restructuring in Uganda. What to expect and how to prepare. What to expect and how to prepare. 3 years ago, no one would have thought about COVID. 3 years ago, this place would have a tent with 600 people. Today, you have 200 here and another 400 online. We didn't prepare for that. That is an advantage, but there are challenges that have been created by that. And therefore, the theme today is actually quite apt and appropriate: what to expect and how to prepare. What to expect may be difficult to anticipate, because then you try to play God. But how to prepare is, what do I need to do? And I think what URSB has done today to come and train people in these spaces is actually very, very important, and is applauded. I am an insolvency practitioner myself, a registered insolvency practitioner, and I've been for a couple of years. Obviously, it was very difficult a couple of years ago to explain to anyone that you're an insolvency practitioner. It was like telling someone, a couple of years ago when funeral services first started, everyone said, who dares deal in this business? You're an undertaker. What are you? But it is a reality that we are going to die. Now, insolvency practitioners have been known to be undertakers. The moment you said you're an insolvency practitioner, everyone thought about winding up and bankruptcy. But like the chairman said today, we are discussing a whole new paradigm, a whole new thing. We want to see insolvency practitioners as saviors, as rescuers of business. I commend the URSB for the tireless efforts in creating awareness in the insolvency spaces and building capacity of stakeholders to handle insolvency cases in Uganda. URSB staff, you make us very proud, and I personally am very honored to be associated with you. You know, in our space today, to say you know someone can be dangerous, because they can tell you what that person does, and then you can't reverse the fact that you know the person. So these days we are careful whom you know, but with URSB we are very, very proud to be associated with you, and we're always honored to keep your company. For when the company you keep tells you who you are. So I'm very happy to be with URSB. As most of you are aware, Uganda enacted the Insolvency Act in 2011, which consolidated a number of laws. Insolvency incorporated modern approaches to insolvency practice as a corporate rescue mechanism. The Act provides for the Office of the Official Receiver, who is the Registrar General and the regulator of insolvency in the country. Previously, you did not require any particular qualifications to be required to do insolvency practice. But with the enactment of the law, because of the risks that were posed by this, the enactment of the law brought in the need for qualifications. And that was a major, major change in our space. Because now for you to be an insolvency practitioner, you must be a lawyer. That means you must have certain skills, and you must have been tested to have those skills. Secondly, you must be an accountant or a chartered secretary. And more importantly, you must possess professional indemnity. Professional indemnity is an insurance. But why it is extremely important and why it is put in the law, you know, in the Advocates Act, there is no requirement for you to have professional indemnity. It is a practice that has grown and has come to pass. But in the Insolvency Act, you are actually required to have professional indemnity, because you have to explain why that patient, that company that was placed in your hands actually collapsed. And that's a huge responsibility. It's a huge responsibility. Like we are telling you, the practice has changed. Before, your business was to undertake. You get the person and make sure they are dead and bury them. That is what you did with the company. Today, they are telling you totally different, saying, no, you must rescue that entity. And therefore, that professional duty that you have to this company requires you to have professional indemnity. The Insolvency Practitioners Regulation 2017 have provided for registration of insolvency practitioners by the official receiver. Like we have the Advocates Act requiring us to be registered on the roll. Even for you to practice as an insolvency practitioner, you must be registered on the roll with the official receiver. I've been reliably informed that the number of registered insolvency practitioners is gradually increasing over the years, and I encourage those of you who are not yet registered to do so. With growth comes challenges, Registrar General. A couple of years ago, the legal fraternity had so many people, and we had so many problems. As the numbers grew, even the problems grew. And you know what I am talking about, and we need to be very, very careful. Because this insolvency practice is very intricate, because one wrong mistake, in fact, any kind of dishonesty in that process will sink that entity. It's already in trouble. So any chance of dishonesty will sink that entity. And with that comes a great responsibility on the official receiver to make sure that the persons you register on this roll are actually people of great integrity. As you are aware, you are a key player in the insolvency ecosystem, which essentially includes yourselves who, when you act on behalf of the debtor, creditor, the regulator who oversees the insolvency proceedings, the courts of law, which are headed by Justice Sekana here, which administer justice in the process, and then the debtors and creditors who are at the center stage of these proceedings. You actually sit in a very, very interesting place. You have debtors, you have creditors, you have the owners of the company, you have an entire ecosystem, and you as an insolvency practitioner are sitting in there trying to balance the interests of all these people. And you must make sure that all these people come out happy. The only way you do that is by making sure that entity survives. I'm informed that judicial officers were trained yesterday in insolvency practice, on insolvency law, and I urge Ursb to continue training all stakeholders to enhance their capacity to expeditiously handle insolvency matters. Insolvency matters are not matters that you can adjourn. This person is in ICU, this company is in ICU. It needs quick action. I've seen a number of decisions handed down by Justice Sekana, and the UTL one most recent. And they are quite interesting because you see what the court is trying to do. The court is bending backwards to make sure that it assists this entity to survive. And therefore, the more practice that the judicial officers get, the better for all of us. This year's conference has been organized at the right time, like I said earlier, and most importantly, under the right theme. As the country recovers from the economic effects of COVID-19, there must be a mindset shift from corporate failure to corporate recovery and restructuring. Financially ailing businesses, which are many in light of the COVID-19 effects, must be supported to survive rather than being liquidated. It is your duty as an insolvency practitioner to explore the rescue mechanisms available to such entities and work out essential and corporate turnaround. This will promote economic stability and will stand to benefit as a country. I don't think anyone wants to tell us about what has happened to COVID. All of us, it has reached us, it has gotten to that point, it has knocked on your door and probably entered your business. And it has been extremely disruptive. So the rules under which we operated 2 years ago are totally different. 2 years ago, a person didn't pay you, you want to wind them up. Today, you need to think very carefully what it is that you're going to do about that entity. In the place where I sit right now, I see a lot of these. At times, you even start imagining that it has become the song, COVID-19, COVID-19, COVID, but it is the reality. And therefore, we must start thinking outside the box, try and determine how is it that we are going to best help these companies to survive. Generally speaking, insolvency refers to a situation where a debtor cannot pay the debt that he or she owes. It may be a cash flow issue, it may be their management issue, it may be indeed a failed business, it may even be fraud. You, the insolvency practitioner, must determine which of these or the many possibilities it is. Is it fraud? Is it management? Is it just simply a cash flow problem? You must determine all those. I was sitting and dealing with one of our colleagues discussing an entity, which was a very big entity but was going under. And the question therefore was, do we invest in this entity? If we are to invest in this entity, are we taking shares? And the question was, if you take shares from that entity, how helpful have you been as a company? Because you're taking benefit of an insolvency situation. What you're supposed to do is assist that entity to get out of that, because you have actually determined that their problem is a cash flow problem and a management issue. So it is a very intricate position in which you find yourself as an insolvency practitioner to determine what is this person suffering from. This is the closest you have been to being a doctor, because all of you, as you saw, the professions that are required here, we have never been doctors. In fact, biology was a struggle, mathematics was a problem, every science you see us with 7, 8. Now all of a sudden we are sitting here, what is this entity? I think lawyers sat somewhere and these practitioners said, we need to figure out something that we can also be called like doctors. So now we are talking, what is this suffering? What is this company suffering from? What is this company? Is it, oh, it's suffering from a cash flow problem. I think that makes us feel very, very sophisticated, but that is the reality. And your job now is to save. The Insolvency Act and the Companies Act have numerous rescue mechanisms that ailing businesses can embrace and avert going under. The Insolvency Act, Part 5 and Part 6, provide for the individual and corporate restructuring that involves a reorganization of the debtor's business affairs, debts and assets. About 3 months, 2 months, a month ago, someone came to me, said, I actually didn't know this person originally, but was introduced by someone who told me, I have a matter in court, and the court has given me a notice to show cause, and I know I don't have the money, but I have got all these things going to come up in the next couple of months. But if they close this business, if they sell this asset, I will not survive. So I said that now what do I do? How do I deal with this? So I said, okay, the most I can do is I can give you one of the lawyers from government to go with you to court and explain your position to the court. And the court listened and said, oh, so all you need is time. And the court said, how much time do you need? Said, oh, I need until May 25th. The court said, no. Since you have given us until May 25th, we are going to give you until, they said July 5th, so that we do not go into court vacation with this matter sitting there. I was actually very impressed by the registrar who handed down that decision, because selling off this person would never have paid off that debt. So the debtor and the creditor would both collapse. But at least it gave an opportunity to both of them to survive, and all it did was months. And I was just thinking about when I was going through this paper today, and I just realized that, wait a minute, this thing is coming to us The May that they are talking about, the June, is coming on so fast. And none of them has died so far. So we are hoping that that will help. So we need to start thinking outside the box. And as practitioners, especially lawyers, as you go to court when your colleague says, all I need is time, or all I need is for us to reorganize ourselves and figure out how we can pay this, we need to start looking at each other and saying, what is the purpose of my existence here? The purpose is to have my client survive, but it does not have to include the death of the other one. So the purpose of the Insolvency Act is to assist recovery, not to destroy, as has been the misconception. Uganda Telecom Limited provides a very good example, and I would like every insolvency practitioner to go and study Uganda Telecom, because I think it is one of those entities that has been quite studied and handled within our system since 2017. Provides a good example on how we can support financially ailing businesses to continue in business, promote economic stability, and preserve jobs. As some of you may be aware, UTL in 2017 was on the verge of being liquidated. Presented the company was clearly unable to pay its debts. It was unable. Everyone knew that. A decision was taken to place the company in administration, which offered protection and enabled it to reorganize its affairs. The court actually came in and said, no, I am placing this company, because what had been requested was a liquidation of the company. The court looked at what assets UTL had, looked at what the prospects in the telecom sector were, and said, no, I will not liquidate this entity, because liquidation means break it up, put it together, sell it. Court said, no, I'm placing you under administration, let's go and compare. As we speak, the company is still running and is soon getting out of administration. Not soon, it is actually practically out of administration. It is offering services and employing your brothers and sisters. This was a fully government-led effort. This is what we want to see you advocating for as we build a country together. I am happy that the theme and the topic for this conference is in line with this approach. It's a very, very good example of how you can very easily and very flippantly destroy a really good thing. Government is committed to this cause and has also put in place funds aimed at supporting ailing businesses. I implore you as insolvency practitioners to encourage your clients with struggling businesses to engage the financial institutions and benefit from the recovery fund. There are recovery funds out there for small, medium-sized businesses in Ministry of Finance, and then there are those in UDB for the really big entities. As practitioners, your job is to go and find that money. That's your job. That's your job. That's why you're being paid. And by the way, insolvency practitioners are paid very highly if you survive. If the entity survives, you get very good pay. Your job is to go out and find those resources. So the ailing entity is placed in your hands. Go out and look for these entities. And I'm telling you now that government has made available. We have also commenced the process of amending the laws regulating insolvency processes and practices in Uganda. That is the Insolvency Act 2011, and the Companies Act. Key among the proposed amendments is reducing the time to formally wind up company and to have no assets and liabilities. The process for winding up is really long. Especially one entity which says, I can't do this anymore. I need to pay these people and get out of this. The process is too long. And with that length of the process, it's also expensive. The amendments also seek to provide for the post-commencement financing and priority of such post-commencement financing in settlement of claims. We cannot talk about restructuring when we don't make it possible to access financing for the restructuring process. We are doing our best to achieve the desired insolvency legal framework, to reduce the cost of doing business, and to encourage foreign direct investment in the country. With your support and commitment to the insolvency practice, I believe we will be able to build a strong insolvency system that promotes a quick and easy exit for those entities that must exit the market, and support for those that must or can survive. The approach for their survival is what will be discussed in a greater part of this day. It's unfortunate that today I will not be able to be with you for much longer because of the processes that are ongoing for the replacement of the speaker. But it was a very interesting, there are very interesting topics being discussed today. What are the approaches to survival? What are the options? What do I have? Can I borrow? A company that is insolvent, that is in administration, you know how difficult it is to get financing from ordinary corporate entities. But there are methods that have now been renowned and have been practiced that have actually worked. Banks are risk takers. Insolvency practitioners should also learn to be risk takers. And risk takers must be calculated risk takers. But that is what is going to be discussed today. I once again applaud Ursb for its deliberate efforts in sensitizing its stakeholders on insolvency matters. I thank you for participants for sparing time to attend to this conference and to enrich your knowledge and skills in insolvency law, and I urge you to apply it while handling insolvency matters. I thank you, our distinguished presenters, for sparing time to share with us your knowledge. It's one thing to have the knowledge, it's a totally different thing to share it. And a person who shares knowledge is a person who must always be applauded, because I could have this, keep it to myself, and be the only person who knows how to practice insolvency, and therefore everything just comes to me. So we really, really thank you and applaud you. The NRM government is committed to developing the business space for the benefit of the people of Uganda, to make sure that businesses survive so we can create jobs for our people. Government of Uganda is committed to making business processes smoother and cheaper. Thank you. I wish you all fruitful deliberations, and I declare this conference open. I thank you all for God and my country.
Thank you very much, the Honorable Attorney General. Thank you to the Chairman of Ursb, and thank you to the Registrar General for those remarks. And now, participants, our next item on the program is a group photo and a tea break. But before we proceed, just to let you know, the places of convenience are to my left. Just go around to my left, and you'll see the markings there for both male and female. So I'll now request our guest of honor to join us for a group photo, just to my right. He'll be joined by Justice Sekana and some participants in the group photo. So we can cross to the right this way. Thank you. As we go for the group photo, just to let you know, the tea break will be in the tent to my right. We'll have about 15 minutes for that tea break, and then we'll get back in here for the next session. The online participants will take a break for another 15 minutes, so we'll get back online in 15 minutes. Thank you. Members of top management, please join us in the group photo. Thank you. So participants, please, you can take the tea break. If you're not joining the group photo, please take the tea break. We'll have 15 minutes. It's 10:32, so give ourselves 15 minutes and get back here. That would be about 10:47. The tea is right there. I've been advised that the participants are requested to please join the group photo.
Are you a business owner burdened with debts? Do you want to exit business or seek other business opportunities and start afresh? Ursb offers you options of corporate rescue and liquidation or winding up of your company. We help you minimize the risks to your personal assets, estate and credit by providing satisfactory advice on the next possible options in such a scenario. For more information, visit our offices located on Plot 5, George Street, Georgian House, or visit our website at www.ursb.go.ug or call our toll-free line on 0800 100 006. Are you a business owner burdened with debts? Do you want to exit business or seek other business opportunities and start afresh? Ursb offers you options of corporate rescue and liquidation or winding up of your company. We help you minimize the risks to your personal assets, estate and credit by providing satisfactory advice on the next possible options in such a scenario. For more information, visit our offices located on Plot 5, George Street, Georgian House, or visit our website at www.ursb.go.ug or call our toll-free line on 0800 100 006.
Dear participants, we'll be starting in the next 5 to 7 minutes. We'll be starting in the next 5 to 7 minutes, so please try and get done with the tea, then we can get on to the program for the day. Thank you. Dear participants, everyone else still in the tent, please make your way back to the conference venue so we can start the second part of our proceedings. Participants in the tent, please make your way so we can start. Thank you. Final call to all the participants in the tent. Please make your way to the conference venue so we can get on to the next item on our agenda for the day, which is a presentation. Please make your way back so we can start. Okay, I see we're all set. Ladies and gentlemen, from the program, you'll notice that the next item is a presentation. It will be done by Honorable Justice Musa Sekana, and it will be on the topic countering abuse of insolvency processes, the judge's perspective. It will be countering abuse of insolvency processes, the judge's perspective. A quick bio on the Honorable Justice Musa Sekana. Justice Musa Sekana is the head of the Civil Division of the High Court of Uganda. He holds a Master's in Law from Barbados, a Bachelor of Laws degree from Makerere University, and a postgraduate diploma in legal practice from the Law Development Center. It is my privilege and honor to welcome the Honorable Justice. Over to you, Justice.
Good morning, ladies and gentlemen, or participants, whichever is appropriate. I'm presenting a paper titled Countering Abuse of Insolvency Process, a Judge's Perspective. Let's begin by appreciating the law of insolvency in Uganda. The Insolvency Act is the principal legislation governing insolvency in Uganda, supported by regulations, insolvency regulations, insolvency practitioners regulations, and insolvency investigation and prosecution regulations. The Insolvency Act provides for liquidations, receivership, administration, bankruptcy, arrangements, and cross-border insolvency. The Companies Act has provisions for compromises with creditors, arrangements, amalgamations, and voluntary winding up. The nature and purpose of insolvency proceedings. Generally, insolvency proceedings aim at efficiency and equitable realization and distribution of debtors' assets while balancing the interests of various stakeholders. In the matter of Maria K. Motesi, court stated that proceedings in bankruptcy are meant to compulsorily administer a person's estate for the benefit of his or her creditors generally. The primary objective of bankruptcy law is to administer the estate of an insolvent so as to enable him or her pay his or her debts. The law facilitates a fair and equal distribution of available property of the petitioner among creditors. Secondly, the object of the law is to free the debtor of his or her debts in order that the debtor may make a fresh start as soon as the debtor is discharged by court. Thirdly, bankruptcy proceedings enable the court, the official receiver, and creditors as well to establish reasons of insolvency of the debtor and presumably deter people from rashly incurring debts which they are unwilling or unable to pay. The proceedings must be initiated in a competent court or jurisdiction in order to achieve this purpose. High Court has jurisdiction on all matters concerning companies or cross-border insolvency matters, while a magistrate's court has jurisdiction to handle matters whose value is below 50 million, as per Section 254. We have witnessed in the court a practice of lawyers trying to do what we call forum shopping by bringing claims which don't fall within that ambit. Recently, we had a matter where someone listed and was trying to get personal bankruptcy proceedings to be declared bankrupt, purposes of avoiding, I think, the creditors running over her. And when I tried to interrogate her claim, I told her, now, can I have proof of these dates you have listed? Put a clear statement of affairs, and I borrowed from this circle, I borrowed from this. Say, now, I need documents. It's not about just talking about it and putting in your statement of affairs. So when I insisted twice, then the next thing she withdrew. Now, I didn't understand what her intention or motive was, but those are cases where it could have been true that maybe there was a small debt, but is finding herself in the High Court to get some protective orders, maybe against harassment, which was imminent. Abuse of insolvency proceedings generally refers to the institution of insolvency proceedings in bad faith and can be manifested in different ways. For example, commencing insolvency proceedings before exhausting other modes of execution. Insolvency proceedings should not be used as a debt collection tool. Bankruptcy / winding up orders should only be granted after other modes of execution have been exhausted. In the case of Recompany 1573 of 1993, Judge Herman J. noted it's straight law that the company's court is not and should not be used despite the methods, in fact, often used, adopted. A debt collecting court. The proper remedy for debt collecting is an execution upon a judgment, a distress, garnishee order, or some procedures. You realize most of the cases that we receive are not genuine cases of insolvency. I think as lawyers, we have devised, or you have devised, mechanisms through which you would squeeze the judgment data, and especially where it's a company, into making a quick payment. Of course, you are aware or alive to the fact that any person whose company is threatened with a winding up and yet it's not a going concern has every reason to panic and get worried, because for one reason or the other, of course, if it goes before a judicial officer who does not apply their mind properly, he can decide to do the unthinkable. That's why the shareholders or the company owners don't want to take anything for granted. But you realize that someone has just won a case, and then the advocate wants to make ends meet. He has won in high court and is aware that there are other processes awaiting, Court of Appeal, Supreme Court, but just to squeeze them out, say, no, let's go for this. Now, the purpose of this is to ensure that you exhaust the processes which are set out in execution. And we are aware of all these, but deliberately, lawyers or advocates avoid that. So you find someone has not even gone to the registrar for execution, and the next thing is triggering the execution process by issuing a statutory demand. And definitely, someone must now go to court to set it aside. So it is deliberate, because sometimes even the other part has served the notice of appeal. You're even aware, desperate as you will be, just know that this person has an opportunity to exhaust all the appeal process, whether the case is bogus or not. Give them a chance in court, instead of going for the harshest mode, which would be even an extreme or a rare one in the circumstances. I've also witnessed currently there are some applications which are coming up where you advocates are trying to lift the veil. You have a judgment against a company, then when you realize that the company doesn't have anything, then you come for lifting the veil. At least I had one, I think they were trying to pursue the Katikkiro of Uganda, Maiga and Bule, Chitobero. I think someone won a case against them, and the next thing he came for lifting the veil. I say, what has happened? They said, no, the company has nothing. We cannot. They say, then what? If it has nothing, then should you go for the directors? Because I think they own the company with their spouses. I told them, no, we cannot allow this. Otherwise, we would be now causing chaos. Whoever feels that we are all shareholders in some companies, which we don't know whether they're even, but they're still on the register. Now, as I'm in court, someone is coming for me to say, no, we are going after the directors or shareholders. We are lifting the veil. So it is a practice which is also now coming up whenever. I think I even have another matter recently, but I told the advocate in my face, I already decided the other one. Go and read it, and I think that's the same reasoning. I don't think you are going to make anything different. But let's avoid such abuses. I know those who are not here may not be aware, but they will be able to come up with such ingenious ways of squeezing parties into payment, effecting payments. Debtors or borrowers who don't want to settle their obligations and apply for insolvency orders to defeat creditors' claims. Usually, these are a bit straightforward. When someone realizes that he's been cornered, then he will try all modes of staying. I gave the case of Tibeingana versus VD. Tibeingana is one of your own. He's an advocate. I think he had a debt, and as he was being squeezed in execution, Justice Gaswaga had issued a warrant. So he ran to my court saying he wanted to get interim protective orders. So when I interrogated, I told him, now, first of all, you're even running away from, before the other party came, I said, okay, can I know how the debt arose? It's an old debt against this person, I think $250,000 US, which had, now the interest had accumulated about 400,000 USD. He had been given enough time in execution division until when Justice Gaswaga issued the warrant. Then that's when he ran. Now, deliberately is running away from the execution on the other side, and he thinks he could have a chance this other side. And that's why, as courts, definitely that's abuse when you know you file other matters well knowing that there are other proceedings over the same issue. So as soon as it came before me, and the other party actually brought all the orders which came from execution division, maybe he would have taken a day had the other party not appeared. Or sometimes we may not know as court that there are other proceedings. That's why when you avoid proceeding ex parte, the other information comes in, and when it comes in, you're able to appreciate that actually this person is abusing. Because sometimes we may not be able to know if you don't avail that information. And ignorantly, I may issue the order, not being aware of the fact that there are other proceedings somewhere. But at least with that one, I dismissed it. And later, I think he filed something else. I know, being a lawyer, he was interested in using the legal process to protect him. Basically, that's what he was trying to do. But whatever he was doing, the fact, because this was just one date, now later he came and tried to disclose all the dates, which were many, and all of them came objecting towards what he was doing, because there were even parallel proceedings, I think, in commercial court, and these ones in execution. So Midu, I think, he didn't even make a full disclosure, because later, when he gave a list of the debtors, he omitted some 3, which was also an act of bad faith. You see, you must come clean. You want protection of court in insolvency matters, you must make a full disclosure so that we know your status and get to know how you can be really helped. Where a debt is generally disputed, then you cannot really come up with insolvency proceedings. And in the case of winding up of Silver Springs Hotel Limited versus Bandukari Mohammed, the court noted it would be unfair for the respondent to be wound up on a debt which is still subject of an appeal process. This was before me, and the owner of Silver Springs, I think, is Shoku, that Indian. And they had a case against him, and they were trying to wind up the hotel, which is, it's not a going concern anyway, but they were pursuing that. So the other party only came with a notice of appeal. Fine, it may not be an appeal, but at least it's notice to me as court that actually I'm appealing that decision. Of course, what was unfair that the other counsel had taken quite some time to prosecute the appeal. And I think at one time when I was making inquiries, I wanted to find out the status of the appeal. It was just insisting on, okay, the notice of appeal was in court. Well, it would be faulty, of course, because it's just using the appeal process to delay a payment. But you as a lawyer who is affected, you know better what to do if someone has dumped an appeal there and is not being prosecuted. Maybe you go and move the Court of Appeal to have the appeal dismissed, and then you are able to execute against this party instead of just coming for insolvency process without allowing the other party to exhaust the appeal process. Secured creditors selling assets at undervalue and later claiming the balance for the debt from the liquidator. I think some banks can be identified. You're all litigants, you know the challenges people face, and the banks, their policies of forced sale values. Of course, if a person is secured, the purpose of the insolvency process where should be able to allow a party maybe recover on their own. But we have cases which you are all aware of where outright the secured creditor, because he has a deed, decides to even straight away appoint a person to do the sale. And when a person is trying to attempting to do the sale, basically is doing it purposely to defeat and not to enable the other person to recover a meaningful value, maybe it would offset other debts. So secured creditors are equally to blame at undervaluing and failing to recover their full amounts. Next, we have commencing insolvency proceedings with the aim of benefiting a single creditor. Insolvency proceedings are intended as a means for a single creditor, are not intended as a means for a single creditor to enforce his or her debt. They must benefit the general body of creditors. This brings out, I cited that authorities from Singapore. You see, most cases when the company not performing well, you find it's indebted. It's only fair that when you are instituting proceedings, you are aware or get to know who are the other creditors. Because if you don't disclose or you hide that fact, basically means you are abusing the process. Because you're trying to be smart that you went to court first and you automatically got a remedy before the rest. But it's always better and important to have that interrogation of the status of this person to know where they stand. Now, sometimes this happens when one person maybe has a judgment against others who don't have a judgment. It may be a bit tricky whether you should wait for everybody to come to court, then you go for your insolvency proceedings. But it's a question of fact, depending on the circumstance of each case. Now, the one who has gone to court first and maybe obtained a judgment is at liberty to pursue their claims. We cannot say they should wait endlessly for the rest who have slept on their rights. Equity helps the vigilant. The one who is aggressive will definitely be able to recover before. So I think we shouldn't interpret it to mean that a person should wait for all of you, the creditors, who have slept on your rights. If I went to court, obtained my judgment, and I'm pursuing it, and the debt is not satisfied, I've exhausted the execution process, no debt, no payment has come through, then I'm at liberty to. So I think I shouldn't be blamed at that stage to think that I'm selfish or I'm a selfish creditor who tried to deny others an opportunity. Of course, this also goes hand in hand with the nature of the proceedings which you are really pursuing. It must be satisfactory that the due process of all other modes have been exhausted instead of trying to get into insolvency as a means to only recover for yourself. The courts have an overriding duty to promote justice and prevent injustice, and should not entertain insolvency proceedings if they would amount to an abuse of court process. At the end of the day, it's the duty of the court. in whatever we do to ensure that you give appropriate orders. Those insolvency orders, of course, as we've noted earlier, they have far-reaching effects and consequences on a company. Just imagine running an advert that this company is going under. When they have dates with companies or with banks, straight away they will swing into action. Some of you even have the audacity of even trying to talk to court or to a judge or a judicial officer. Just help me to issue it, and then I'll shake him up and the party will give me something. Or basically you're using the process for bad motives. At least I had one, I think, women in Tororo, and I said, but where have you been? Why now? Because the other person actually just argued one point that actually, because I won the flag, now he has woken up, or she has woken up to instigate, to set the insolvency process by issuing a demand. And I asked them basic questions. Okay, did you go for execution? Go for execution. You don't need to do this. This is not a mode of execution. First show code that you have. It's true the debt was not paid. I think even at that stage, the other party was willing to even make a part payment. And the other lawyer did not even want that part payment, by the way. So it was basically for bad motive. I think it was Counsel Bianca was representing the other party. He said, my lord, we have a part payment. He said, no, he says he doesn't want it, so me, I'm not an executing court at that stage. I'm here to determine the process. If you think, then you go out and negotiate. But even by the time I determine, they are not gone for the execution. So that is the duty of courts here to assess all this and be able to come out with appropriate orders. The law has empowered judicial officers with a number of mechanisms and tools to prevent abuse of process. Because when you get into winding ups, usually we don't have sufficient information. Now, the starting point, and which sometimes parties who come would never make full disclosure, you must interrogate. And sometimes I begin by even sending them to the official receiver, so that the official receiver helps me to get into an inquiry into this company. So when the person appears, I say, no, can you go and serve the official receiver? I want a statement from the official receiver, because as court, I don't have the capacity to interrogate. Because you may even come and say, actually, I don't have any, maybe I only have one date, and yet the official receiver finds otherwise. But this can only be done if the court exercises or uses the powers it has to really verify claims which have been presented and go behind what is presented. Because most of these processes, I know under execution we have examination of the judgment data, which is a mode of trying to establish or the execution which can be carried out. But when a party presents the dates that he has, the court should not just take it plainly on the face of it that actually this is what the court is going to do. Now, still related to this abuse, the powers of the judicial officers to prevent abuse. Of course, as I think the Attorney General stated in the morning, the need to expedite the hearing. But some of them, you realize there is no urgency. So it means there is no danger. But there could be also an abuse where I think we all heard of what happened during the Nakumatt saga, where the party appeared, wanted those interim orders, and the judge gave a longer date than was necessary, and that's what led to the chaos when the company went under. Because when the directors ran out of the country, the judge gave 6 months ahead. That was the end of Nakumatt. The poor directors had no option, ran away, and they left all the creditors at their own mercy. Started becoming survival for the fittest. Grab whatever you can and you get out of it. But at that stage, one of the creditors, the landlord, obtained an order from court. That's what triggered. And I believe that could have been also an abuse of court process. Went to Mengo, obtained obtained a distress for rent, and came to close the premises. Now, all the suppliers got in panic. But if they had run any earlier, it would have saved the day in one way or the other, but that couldn't be. So the abuse also could happen where you know you're not alone, and there are many others, but you decide to go it alone and you cause a stampede to the whole process. Powers of court to inquire into affairs of the insolvent. Section 22 of the Insolvency Act allows court to order for public examination of the data on his affairs, dealings, and property. And Section 23 empowers court to require any person to file an affidavit containing an account of his dealings with a debtor. Now, this is a power which really, as I've been emphasizing, allows the court to make that examination. I think I've had it once or twice where someone wanted to be declared bankrupt. Of course, I told him, okay, just to assist the lawyers, because the lawyers were at a loss, what do we do? So I told the lawyer, let's begin with bank statements. So I told the counsel for the petitioner, I want the bank statements for the last 3 years. Then they failed to get them. Then they came back and said, no, give us an order. The banks want an order. I said, I'll issue them. So at least that's the starting point to know whether there have been any. But what helped in that transaction, in that case, opposite counsel got information that this person had sold a building along Uganda Road. So when he was confronted with that information, then of course tried to make lies around it, but he could not get around it. I think he was saying that sale had occurred 5 years ago, but he only executed the transfers a year ago. Now, he said, no, we want to know what was that transaction about, how much money was involved. He was saying they swapped, he was indebted to that person, and it was not straightforward. So later, when he was also put in the dock to be cross-examined over the statements and his affairs, at least there were several lies, and he realized it was not taking him anywhere. So he accepted to go and satisfy the debts and abandon the petition to be declared bankrupt. So the person comes well knowing that if I get my day, maybe I was lucky that I was able to get all this information. But if you're not able to get this information, then it means you're not able to unearth all these dealings or transactions. Of course, the 23, which allows a person filing an affidavit, of course, it might be helpful, but we all know how these affidavits are made. They never contain the truth. So if you take it plainly on the face of it, that because he has sworn an affidavit, I mean, we don't respect oaths in Uganda. That is a fact. We all know that. Even a person is telling a lie, but of course we can hold them liable to giving that false information. Court's power to set aside voidable transactions, these are laid out in section 16 to 18, to include transactions at undervalue, voidable charges created within a year preceding the liquidation, insider dealings. Normally where a person is trying to avoid payment or satisfaction of creditors' claims, sometimes unless a person is so smart, but usually they are not so smart, you find a year before, that's when he realizes he's not able to pay. And he gets into all those tricks of now, maybe let me take this into the kids' names, maybe let me get this to a crony who will be able to hide it. Because no one wants to go and come out to say, I'm now broke, and have been declared bankrupt. In one way or the other, he would definitely say, but I think, let me see what I can hide so that at one time I may get it back. Now, the court's power to interrogate, like I said, for the other lawyer, I said, the other part, I said, can I know for the last 3 years? That will help me assess whether you are genuinely broke, that you're not able to satisfy to pay your debts. Now, that should also be assisted by the lawyer for the other party to also do a fact-finding inquiry. What did he have before? Maybe is he the type who has been disclosing his wealth to IGG? Maybe you can get some information from there. Maybe you may have to find out from the cronies or relatives, because sometimes they may know or they may be aware of. If they're titles or certificates of title, you may know when they were transferred. Assuming 5 titles are transferred in the year preceding the petition, those can't be genuine transactions. You just have to go behind that. And that's why the court has the power now to nullify those transactions. Basically, they're trying to abuse court process. It can only be abused by revoking those transactions or the person topping up. Assuming the building was $1 billion shillings and it was bought at 300 million. No, I think this transaction is questionable. At that time, you wouldn't have sold this building at such an amount. Now, the court at that stage is avoiding the abuse. Court may make orders requiring a person to pay the liquidator, receiver, or trustee in respect of the benefits received by that person as a result of the transaction, the sums which fairly represent those benefits, or requiring property transferred as part of the transaction to be restored to the company or the bankrupt's estate. Because if the court discovers that there was that abuse, that intended abuse, it can overturn that transaction and ensure that the same goes back or the proper value is obtained to ensure that they meet their obligations to the different creditors. Discretion of court in making and revoking insolvency orders. Insolvency orders are only made if court is satisfied under C sections 20, 92, and 120. Insolvency orders can be annulled, revoked, or set aside or modified as provided under section 44, 137, and 169. All these are intended to avoid these abuse, which may end up affecting the creditors who may not take full benefit. Then the court's supervisory powers. Court supervision of insolvency process, sections 51, 117, 139, 173, 195 give court supervisory powers over insolvency office bearers. The court may give directions on any matter arising during the course of the insolvency, confirm, reverse, or modify any act or decision of insolvency office holder, order an audit of the accounts, and review and fix remuneration of the liquidator. At least it's always fairer that the court takes charge or remains in charge of the insolvency process. I think as the AG stated this morning, any act of bad faith definitely will affect the company. And really, I think that emphasis of people being of integrity is very important for the insolvency practitioners. Because if the court does not do what it's supposed to do, or they give its supervisory powers over the process, a lot will be done. A lot of damage will be done. Much as we are emphasizing trying to save the company, there are others who don't do that. There are others whose intention is to accumulate wealth or get the best out of this carcass. So to save whatever you can get off any thigh and run away with it. You don't care where the company remains or not. So the supervisory powers will always come in handy. And once any decision is taken by you, the administrator, or the insolvency practitioner, it's bound to be overturned if someone makes their case. And this also avoids those other problems associated with the after effects of a liquidation process. Remember, you are dealing with a company whose shareholders are not happy that it has gone under. Now, should they find any fault in whatever you have done, be sure of other cases arising out of your whole process. And you may be made personally liable for some actions. I can give the example here of UTL, which is almost the subject of discussion, or which has been the subject of discussion by the Attorney General. I think several things have been done, and many more are being done to ensure that we save. Of course, it's a bit clearer because it is the court which appointed the administrator of that company, and therefore, with the court's intervention, it means that whatever the administrator does, they must report to court. There may be those cases where you don't have a duty to report to court, but later if someone challenges, you'll have a duty to explain what happened. So don't think that your actions are not going to be questioned. And the challenge sometimes is the decisions which are being made, whether it was a commercial decision or whether it was a legal decision. But where there is any legal issues involved, you are safer acting on a safer ground than taking a decision which would be questioned, and if court overturns it or quashes it, it may have serious consequences to the whole process. At least we have had about, so far I think there are about 6 applications in UTL where the administrator is seeking directions. And at least I think so far I've given about 4 or 5. I'm left with 1. And where the administrator thinks there's a conflict of laws, instead of taking a decision against a position of the law, is safer acting on directions of court. Now, the direction of court will guide how it is supposed to be done. I think we had the first one on the deed of arrangement, I think, which they found in place, and it seemed to be in conflict with some provisions in the Insolvency Act. And he sought guidance, and the court gave the guidance. Then we had one on pension, which was not provided for. Pension is to government, but the Insolvency Act only talked about NSSF. So the administrator sought guidance and direction from court on how to treat these, how to treat pension. Should it be listed among those priority debts to be paid? Should we rank it with NSSF contributions because they were protected? Maybe the law, by the time the law was made, they never envisaged that there could be a situation where pension, because these were government employees and they had accumulated all their pension over time, and it's in billions. When UPTC was broken up into Post Bank and others, and this was their money which were accumulated over time. So, and later it was transferred to UTL. Now, the issue was how the administrator should treat that pension in rating or ranking the debts. So he sought guidance from court, and I found that actually it should also be rated as employees' contributions, which are protected. Since NSSF contributions are protected, then the same are also protected under that scheme. Then we've had one where shareholders of the company are claiming it was about verification of debts. And it's one of those areas which you are going to encounter, and you must be very careful and cautious. Here the Libyans or the Libyan shareholders, or those companies, claim to have contributed $62 million, or to have given a loan, or I think calling it a loan or advanced a loan to a company. And indeed, they had listed this among the debts. And the administrator questioned that transaction and therefore came to court saying, let them explain. According to the books of accounts, we don't see this $62 million anywhere. How was it brought into UTL? And so I summoned the Libyans. They refused to appear. They had a representative in Uganda who, upon service, declined and said, no, we no longer have instructions. Serve them personally. So they tried to serve them personally in their jurisdiction via email. Well, they were having some email communications. They rejected and they didn't appear. And I found that, no, the claim is questionable and should not be listed and given priority. Because when you read the insolvency, which you're all aware of, there are some principles of subordination of debts, whether the shareholders' debts should be subordinated with others. So that has been partly resolved, of course, pending any other litigation around it. Then recently I had one of, they were seeking directions on how to treat debts arising out of government agencies. Communications Commission, URA, UBC, Uganda Railways, Uganda Electricity Transmission. There were a list of companies which offered services, of course, apart from URA, who were mandated to collect tax. They were also being listed, and there are some principles in the process which provide that you may, if you're a shareholder, and the argument which the administrator was putting forward, whether these debts where government is indirectly involved should be subordinated to the unsecured creditors. And we came to a finding that actually these were standalone entities and they provided services which have to be paid for. So we cannot really subordinate their claims to the other unsecured creditors. But most of these applications are intended to safeguard you, the administrator or the insolvency practitioner. Because imagine taking a decision not to include $62 million. That's not a simple decision to take. I know there are cases which we have cited in some of those authorities. It's not the duty of the courts to determine. Once there are commercial decisions, it's the duty of the insolvency practitioner or the administrator to take. But sometimes I think you need to act on the side of caution, because should there be a backfire, everything will come back to you. Now, the good thing with this UTL thing, the amounts involved are too huge. It's not just a small dispute. I think, as the Attorney General stated here, we need to be very, very careful. And that's why we need to really study it and appreciate it, because it has introduced several things. And as I stated earlier, most of the things which are coming up are not envisaged in the law. So the court is coming in to close these lacunas, to close these gaps. Because the minister says, my hands, I don't know what to do. Now, instead of him taking that decision, it would rather be a decision of court. At least you are cushioned to that extent. Than saying, when I looked at the list, I've knocked off the following dates or claims. This one disallowed, this one disallowed. Then everyone is going to be up in arms that you may be exercising your powers as an administrator wrongly. You may be right, but sometimes to act on the side of caution would be better than being looked at as someone who is acting erratically. The court has the power to remove an insolvency office holder, and that's embedded in the powers of the court. Sections 52, 118, 174, 196 empower court to remove any insolvency office holder on specified grounds and appoint any other. In the cases of Rochodai Patel versus Mukwan Enterprises, which you must all be aware of, the Supreme Court held that the liquidator's actions were fraudulent, unlawful, and breach of his legal duty of care to ATM. ATM is African Textile Mills Limited. Court removed the liquidator from office and directed the shareholders to appoint another liquidator. So this is one of those things which I know some people believe the decision was wrong. Unfortunately, it is from the Supreme Court. You have nowhere else to run. I think there was an attempt to, I think one time I had some matter, but when I had a matter by the liquidator in that matter, Mr. Wambuga had a matter before me. Then before I could determine it, Supreme Court came out with a decision. So I told him now I cannot handle anything because now they have even taken away your powers. You are no longer a liquidator. So the application is overtaken by events. And I think there was an attempt. I think they told me they filed some other matter there, but I don't know much. You could follow up and find out. So, and if you appreciate the facts of that case, you can't imagine the amount of damage and the confusion it's going to cause. That decision of overturning whatever the administrator did, it is such a big challenge. There are third parties. There is Mukwano bought the properties, is now at a loss. What happens? There were debts in Crane Bank. Part of the money was used to offset debts there. What do we do? Has the court reversed that? Crane Bank is no more. So you can imagine the confusion that is likely to bring. But this just to caution all others like you can easily fall in that situation. Thinking that you've done it successfully, then everything is reversed by court. That's why the powers of court are still important. Of course, I think the courts also need to appreciate sometimes the facts as they are, because you may do more damage than you thought you are trying to solve. You create more problems than you thought. It's likely going to trigger a lot of cases now. I don't see the liquidator saying, oh, now what happens to Mukwano's money? Part of it was used to pay a loan. Now, inevitably, now they are going to file a suit against the company itself. So you had this loan which we paid, now we want it back. And doing a lot of things to put things right. It's likely to be that direct consequence. In the appointment, we have the Uganda Telecom, where we've said the liquidator was appointed. the administrator was appointed, sorry. So conclusively, insolvency cases in Uganda are increasing, and the growth of the economy and the sensitization. We should be mindful of the fact that insolvency proceedings instituted in bad faith can have adverse effects on an individual entity's overall reputation and stifle the conduct of its business. Insolvency proceedings should not by any means be used as a convenient shortcut to levy improper distress on an individual or company to pay a disputed debt. Courts will not aid debtors to delay or avoid payment by hiding under insolvency proceedings. Courts will therefore strike a balance between the competing debtors and creditors' interests. Because now that it's clearer to everybody now, this is something that we just used to have as under company law, insolvency, and bankruptcy. Now it's becoming a standalone subject. You can even become specialists only in insolvency matters. I think we need to apply our mind to it. It can save several companies. That is true. I have one which is pending, I will not give the parties, where one has run to court. But sometimes we read stories in the papers. So the matter is before me, but I've read somewhere that this person was fraudulent. Now, I'm not so sure, but there is an administrator appointed. But from the story I read, it wasn't coming out, but it seems police has picked interest and is investigating the fraud now. Whereas before me, it's not about that. It's about a failed company with a lot of debts and how the administrator is working around to turn around or see how the payments are going to be made. But if it was fraudulent or it is fraudulent, of course, I'm yet to see the other companies coming on board, but they've always told me they've always been having several meetings to resolve the issues or the indebtedness. Because the directors, the story ran that they have run out of the country, I don't know. But I'm currently dealing with an administrator, who is making reports, and there's even an offer of a purchase. I hope the other stories which are contrary don't affect the process, which is almost coming to an end. But we should be alive to all this that is prevailing at the moment. You as the insolvency practitioners have a duty to ensure that it's a clean practice at least, because when you get to court, the interrogation will definitely be there. It's not just as straightforward as that. And ADR, I think something that we are also pushing parties into. Should juries come to court, can't these people even have an ADR to meet and discuss their problems without necessarily coming to court? Because you've discovered some of these matters, parties come to court as a last resort. Listen, now I think we are on the edge, we don't know what to do. How do we move forward? Let's go to court, then the court will force us to talk. But you cannot even talk before. It's up to you who are involved to engage. You can get into ADR. The former Chief Justice Emeritus is trying to do some ADR, and he told us recently he has helped some two companies, two matters, I think, where parties were. Because some of these cases, we've ended up pushing parties into resolving. They are coming for winding up. I said, but why don't you talk? Someone is assuming that the company has the money and just refused to pay when actually it doesn't have the money. then another one is alleging mismanagement, maybe it can be sorted without necessarily going for the hard one to kill it completely or get it off the register. I thank you very much for listening to me. Okay.
Another round of applause for the Honorable Justice. Thank you very much, Justice Sekana. Now we've come to the fund section. We'll have a Q&A. There will be a roving microphone, just in case your table doesn't have one. There will be a roving microphone. Hamidu and Alan will help us move it around. To our online audience, we currently have 422 participants. Please type your question or query or comment into the comment section, and we'll get them to the Honorable Justice. So if you have any questions, kindly put up your hand. When the microphone comes to you, tell us where you're from, and please have a precise question so we can give the Honorable Justice time to respond. From the online queries, I see the biggest contribution is really to thank you, Honorable Justice. I think the presentation has been taken in very good faith. I see Aklin Aketesia saying thank you for the presentation, Honorable Justice. They would like to get a copy of the presentation. Just to let you know, the copy of the presentation will be availed to all those who have participated in the conference, because all your email addresses were received and the presentation will be shared. I see Chimera Patricia, very enlightening presentation. Thank you, Honorable Justice. Kennedy Babumba, thank you, Ursb, for organizing this presentation. Musabe James Magson, good and practical. Thank you, Justice Sekana. Musamali Martin, wonderful presentation. So it's really, I see Chaboga Simon. This was an eye-opener, even to the finance managers. Thank you very much, Honorable Justice Sekana. So we'll come to the audience here. In case you have any question, like we had said, please put your hand up, get the microphone to you, and we'll get the Honorable Justice to respond.
Thank you. Thank you, my Lord, for an elaborate presentation. And I want to follow up from your recommendation to insolvency practitioners. Olivia Charimpamatov is my name. You mentioned that it's safer for them to come to the courts for directions, especially to ensure that what they're doing is in compliance with the law. My question is more of administrative, and being that you're the head of civil division, would you recommend that then there should be a specialized court for insolvency matters? Otherwise, if they are to come to the civil division and you have to also handle other civil matters, wouldn't that create a lot of backlog if practitioners were to come to court now and then seeking directions of court in terms of how they will manage the processes? Thank you.
Any other? We can take a round of 3, then get back to the others. Hamidu, there's a question.
My Lord, my name is Kenneth Kampurira. I'm an insolvency practitioner. And I have been stressed in the corridors of court trying to get a debt when it comes to seeking the guidance of court on matters that you feel might expose you in terms of being an insolvency practitioner to avoid liability. I have approached heads of divisions who tell you I have a huge backlog, or I have 300 cases to handle, so here's not an emergency. Yet insolvency matters are more of ICU matters. My Lord, how would you advise me or any other practitioner on how to get a quick debt from a busy diary of a judge?
Thank you. We'll take one more.
My inquiry is about the section which you described as abuse of court process. And this, I come from a banking background. We have scenarios of borrowers who pledge securities and they declare that at the point of borrowing, they are not married. So they declare, they swear statutory declarations. Now, at the point of paying back, they do not pay. Now you try to enforce your rights as a mortgagee, and suddenly a spouse turns up, files a matter in court with all the marriage documents, which seem genuine. Meanwhile, the regulator is on your back to continuously take provisions out of your own income. You can't enforce the security, so you're left with one option: to file for a matter of, to declare this person bankrupt. But from your presentation, that is seemingly a matter of abuse of court process. How would you advise, especially the banks in this industry? We are faced with that very severe challenge. So I would like your advice on how we would proceed with such matters. Thank you.
Okay, I think the Honorable Justice can take those. Maybe just to add to what one of the participants asked, there's a question from Paul Waswa. Says, my lord, I think there should be a specialized court for insolvency proceedings. Commercial division is quite overwhelmed. Please give us an idea of your thinking towards this.
Okay, thank you. The first one, I think, relates to even the last one. I think yesterday, the chairperson, the chairman of the board, I think, raised it before the Honorable Principal Judge, who was the guest of honor in yesterday's training. And he requested that we have a specialized court. I think it's something that maybe you could be a bigger voice now. He just made it as a by the way, I think, in his introductory remarks. But I think if you came up with a write-up and you presented it before the principal judge, I think he has the power to move the top management to create a specialized court. If it is not, then there could be also maybe specialized persons for that purpose, maybe those who have undergone through training. Because sometimes the challenge that we have is we are not permanently in some positions. Find one who is trained, then he leaves the division, and it becomes a challenge. But with continuous training to ensure that maybe we equip all judges without even saying one person should be able to. I wasn't trained anywhere that I should be the one involved in insolvency matters, but I just picked interest and I did it. I believe even other judicial officers, we have the same brains. We can all comprehend the same things and do the same to the litigants. But I believe you can write a letter to PJ and then they would contemplate at least creating one, or even within those divisions, they even know what, maybe what court can be created. Internally, before we used to have the challenge between civil and commercial. I think one time I went to civil division and the head had picked all the files and sent them to commercial. Then the head of commercial got all the insolvency matters and sent them to civil division until when I think PJ intervened and said, no, look, I think either court can handle those matters. You don't need to toss the litigants. But now that the voices are becoming louder, maybe that's the justification to have them, to have a specialized court in insolvency. At least when a challenge comes, then it's even easier. Related to what Kenneth said, getting a date, because if sometimes there is a specialized court, they would understand and appreciate some of these challenges, like the case I gave you of Nakumat. The judge didn't appreciate insolvency and the urgency, and unintended consequences led to what happened. Also related to getting a date, sometimes it's not as, okay, maybe we all manage our diaries differently. I've advised colleagues as the head that, because there's been a tendency of people thinking that I have dates in my diary. And I've told them, I think we all have the same workload. Can we manage our diaries? Because we know we shall have those urgent matters. They will come. Now, you cannot say at any one stage when an urgent matter comes that my diary is full. It's just about failure to manage your diary properly, or maybe the judicial officers. And some of you have always come to me insisting that you want me to hear your cases. I've told you, go back. Go back to that judge and insist. The judge must be able to manage their diary. That is one of the key things. Not that I have more days, not that I have more hours. We all have the same. But you just need to know that in the nature of your work, those urgent matters will come. And I normally have time in between. And I will tell my clerk, like, that's urgent, can you squeeze it somewhere? Or I can afford to remove one, and then I put that to avoid those unintended consequences. If someone says is coming to court, sometimes you come to me and, yes, I'm the head, but I cannot direct the other judge that you hear this matter tomorrow. I would only be urging them to do the right thing and manage their diaries. At least I will take a feedback that actually there is a complaint that some urgent matters are not given. Also, we need to bear in mind some matters which you bring are not urgent. So, I mean, a delay on your part should not become an emergency on our side. We are already congested. These are all your cases. Now, some of you receive instructions today and you want a date tomorrow. No. If the person delayed, don't carry an elephant. I've told some of you, you're carrying a heavy load which you cannot take somewhere. If they have come late, don't stampede us. I've already fixed cases today and tomorrow, and you are insisting you want me to give you because your client tomorrow. Did he realize yesterday? Where has he been? He has been going to all chambers of advocates in town. Then finally zeroing on you when it is very late. The bank is selling tomorrow, they are doing this tomorrow. What do you want me to do? They ran the advert 30 days ago. Now you are coming on the 29th day. And that's why I normally chase you. Whether it goes, no sentiments attached, let it go. You will get other remedies. But let's do things in the right time. When you do things in the right time, the judge is able to assess. And I'll be flexible in my diary. But now, this whole week, yesterday I was here, I'm here today. Tomorrow we are in a backlog meeting at Munyonyo. So I'm not at the station. Now you find the lawyers are seated there, they literally want to cry. My Lord, I want a date. My Lord, I want a date. So now why did you promise your client that you are going to get a date tomorrow? You're carrying an elephant. You will not get it. And I normally show you my diary. Now you look, where am I going to fix you? Why should I sacrifice another person who came early, is even organized, and because you want to get, or you are able to talk to a judge and get a quick date? I think it would be unfair. Then Amanya on abuse of court process where the banks, I think usually the challenge, of course, with the banks is sometimes you're also high-handed. That's a fact. That's why sometimes when people run to court with those things, of course, they're also trying to play smart. But what happens, and out of my experience, it's true, this happens a lot. One time when I was advising a bank as a lawyer, I advised that we prosecute all these people who came to the bank and said they were married. They produced different side dishes. One time I appeared before the CJ then when he was in And a similar matter. So he was asking the plaintiff, the defendant, why did you take the side dish to the bank? You mean the bank is there to allow you come with your side dishes and then you say is your spouse and then you refuse? And now, because sometimes they fail to do, or the banks fail to do the proper due diligence, you're also in a hurry to advance money. There's that problem. He has satisfied everything. The boy wants to hit the target. You call them banking executives. He has got, the man wants 200 million. Now when that is put on the boy's portfolio, he's going to get some allowances and you begin disregarding all other things. No, even if you don't have a marriage certificate, you just swear a certain declaration that this is your wife. Now, later, and the man is smart, he's doing it deliberately. Later, he's bouncing back with a real wife, with a marriage certificate, and you are stuck with your statutory declaration. That, oh, now, for us, we have a certificate. And indeed, the woman is the wife. They even have kids. All the proof is before you, as you have said. It's clear the guy conned you. But the banks don't want to prosecute those, their customers. That's what I was made to understand. That it doesn't augur well with the nature of your business. Because one time we had about 6 cases, and they were all with me. I said, no, we cannot allow this. Let's go to CPS, we open a file, and we prosecute whoever presented a side dish. He said, no, I think that is high-handed. That's what the MD told me. Let's try to find a way around it. But if you have already fallen a victim, now you don't again begin using another process. That is a clear abuse. Mitigate your damage and find the best way around it. The money is still around, or the company is still there. Examine them on what they have available, upon which you could recover your loan, instead of now insisting on the mortgage, which already had those challenges. I think that was the last one, yes.
Thank you very much, Honorable Justice. The Director of Civil Registration had a comment to make about the idea of somebody claiming they are married and then they are not.
Okay. Could offer some advice. The URSB maintains registers for all marriages in the country, be it Islamic, civil, church, Hindu. So in principle, whoever is married should be on the marriage register. So the banks should then be able to use these registers to verify information given to them by parties. I know the urgency of banks to dish out money, but if the money you spend to collect it back is much more than maybe a bit of waiting, why wouldn't we then use the available mechanism? At URSB, if you make a request for a search for a marriage, we'll do this and get back to you in hours. That is one. 2, even if the couple approaches you and says, yes, they are married and they have paperwork, ask them to have the same register with us because we verify it, and then you'll have reliable documentation on which to then issue the relevant loans. So my plea to us is that we should use the available services and aid the courts in coming up with the right decisions when time comes, when, of course, we have been challenges collecting back our monies. I thank you.
Thank you very much, Director of Civil Registration, Vincent Katutsi. And thank you very much, Honorable Justice of the High Court. We can now go to the next item on the agenda. From the program, we made some changes to the discussion coming up. The next item was supposed to have been done, but we made some changes, and my colleague Patience will be taking over for this session. It will feature Mr. Kabito Karimaji. Patience, please come and take over this session. Thank you.
Good afternoon, our distinguished participants, the Honorable Justice Musa Sekana, our board chair in absentia. Please allow me to remove the mask. The Registrar General, our distinguished insolvency practitioners, good afternoon. My name is Patience Bushire Karazarwe. I'll be taking you through the next session, whose topic is the final investment decision, the implications and opportunities for insolvency in Uganda. And to present this to us, we have a distinguished insolvency practitioner. He is a managing partner of LegalMark Advocates. He's a qualified insolvency practitioner and advocate of the High Court of Uganda. He's one of the leading insolvency practitioners, like I said earlier. He has also been at the center of major corporate debt restructures in Uganda, but he has also been a consultant in various government projects and also for the World Bank, specifically in Cameroon and Rwanda. I would like to request you now to put your hands together and welcome the one and only Kabeto Karamaji. You're welcome, sir.
Thank you very much, Patience, Your Lordship, Justice Sekana, dear colleagues, members of the practice, members of ULS, Insolvency Practice. It's my pleasure to be here with you once again to share my experience and share this topic with you, my thoughts on this topic with you. I noticed that I stand between you and lunch, so I will be I'll try and be I'll be mindful of what lies ahead. I know that there was another topic that you probably were looking forward to. I am made to understand that there was need for us to change. There was need for Ursb to change that subject, and I was asked to discuss this instead, which I hope you find just as an exciting. I have not had opportunity to discuss this. I was only actually, to discuss this anywhere. I didn't have much time to give it thought, and so you will forgive me if this looks hurriedly prepared. Yes, so everyone is talking about the final investment decision and where we're going and the excitement. Money is going to flow. So in all this optimism, where is insolvency? Should we be practitioners at all? Should we, we normally deal with distressed assets now with a lot of money around. Maybe it's time to do other things, criminal law, family law, maybe land or something. I think the topic we're going to discuss is going to look into that. I've kind of thought that as I prepared this presentation, I thought it would also be useful to look at this topic in the context of East African Federation, because you are not the only recipients, there are spillovers. This money is going to flow into other economies as well, as we'll be able to see, and I'll be talking a little more about that. So this discussion is really in the context of integration. So we do all know that in Feb 2022, a few days before Valentine's, the state governments of Uganda and Tanzania decided to give us a lover's gift in the midst of increasing oil prices and so on. They gave us a final investment decision on the development of oil and gas projects in the Albertine area and the development of a crude oil pipeline from Uganda, Hoima, in western Uganda, down to Tanga, the little port of Tanga on the Indian Ocean coast in Tanzania. The project covers an upstream block and development of an export oil pipeline for what is now called EACOP, the East African Crude Oil Pipeline. And the deal calls country happen under radar. So we're just waking up to this, but a lot of work has been going on already. So for those of you who come from Hoima, please confirm to me areas of Kaiso, Tonya, until about 20 years ago was not any different from the times of Kabalega. Yeah, not any different. But now, the spirit of Kabalega is alive. So that is, I don't see any murmurs of protest, but I think that that assertion is true, at least from the accounts I hear from the people that come from there, Bulisa, Kaisotonya, and so on. So we are expected to see about 3.5 billion going to this project, into the crude oil pipeline. The pipeline, the building, actual building of that pipe, 3.5 billion. Likely to see 3 billion go into the development of Kingfisher, and about 4 billion into the Tanga project. I'm sure you've seen this, and I really want to speak to those because I am amazed sometimes at how much people don't know, despite all the information out there. So if you know, please pardon me. It amazes me. I don't know whether you also encounter. Social media does, I think, has promoted ignorance of her. I don't know. So please pardon me. This is maybe regurgitated and so on, but some people actually don't know. So this is just to show you where this pipeline is going to pass, down into northern part of Tanzania to the port of Tanga. That's 1,444 kilometers of pipeline. You can imagine what is going on already right now in terms of compensation of land rights and so on, resettlement plans. The partners in this Total, CNOC, who are bringing the money, and of course our UNOC and the Tanzanians, Petroleum Development Corporation, working jointly to form this, the shareholders and the EACOP are working closely to, that's how the 10 billion comes in from the investments of Total and CNOC. The expected equipment alone, 500,000 tons. Now, I don't know whether what's the weight of your car? You want to measure that, and I don't know whether you've had a 2-tonner, canter, these trucks that normally, this is 500,000 tons of equipment is going to be brought in here for this project. Now, if that equipment is coming in, what do you expect? There are going to be mechanics to repair these things. There are going to be people to operate them because we don't know how to operate these sorts of things. So the life around this pipeline and the equipment that has to be is going to change. Everywhere you see that is going to change. The pipeline, the route, it's going to change. Social, economic, you're going to see strange-looking children. Yeah, in rural areas, I don't know, for those of you who have been, for example, in the areas of northern Tanzania, Bukoba, and so on, if you go down there, in another 10 years, you'll see very different. Yeah, we're going to see over 70% increase in direct financial investments, FDIs, direct money coming in, new money. So during the construction phase alone, and then there'll be more investment as the oil starts pumping out. We have over 200 barrels of oil per day when production finally settles plateaus. So we are really in things. That's what it looks like. But like I said, I want to look at it. That's the one part of the story. I also want to look at the East African community, because in all truth is that as this money comes in, the dynamics in the region are also going to change. And this East African project, East African community project, is another that, you know, things seem to be happening and we just don't see. I wonder how much we know. Now let's look at just the data of this community. Currently, the membership of this community is 6 countries. You know them. You probably all do. What you don't know is that when this actually happens and grows, it is built to be a potential superpower. So Uganda and this community could actually become an African or the first African superpower. With a population of nearly 200 million, we'll become the second most populous country in Africa. If you read population, please read market. Market. Okay? Population, market. Have in mind that Uganda has one of the youngest populations in the world. Average age 15, 16. If you're 30, 40, 50, you are very old. Very old, Mzee. I have since accepted that when I read this data. Mzee. If you're 70, you're near extinction. You're endangered species. Yeah. So this country belongs to the 15 years old, 15, 16, 17, on average. With 2.5 square kilometers of land, we will be the largest country in Africa. Largest. And the 10th largest in the world. The plan is to adopt English as the official language, but Swahili is widely spoken. Now, I do not know whether you know that in primary schools, Swahili is now compulsory. Do you know it? Some people don't know. Do you know that the national anthem of Uganda has been officially translated into Swahili, and that it is actually sung in Swahili at that level? So things are happening under the radar that we're not. Don't worry, how does this relate to insolvency? I am coming. Isn't it? Just be. Now, as a community, apparently we have a GDP of about 224 billion. But if this community is to actually happen, this GDP will grow even faster. Why? Because already the countries in the region post the highest economic growth rates. And we've done that consistently for the last, 15, 20 years. Growing rates at about 6, 7, sometimes even at 8%. Rwanda, Uganda, sometimes Tanzania and Kenya. That's the average rate of growth. If we actually have this community happen, then we will enjoy economies of growth, economies of scale, that then will spur this faster. Okay? Now, we'll look at how then this fits into the African context a little later. But let me just give also maybe a history that we probably know or don't know. This project has been ongoing for the last, how long? Over 20 years. Can anyone believe it? It's been ongoing for the last 20-something years. The first protocol was signed in 1999, providing for the establishment of the East African Court of Justice, the East African Legislative Assembly, and a secretariat. And these offices working and these establishments up and running, there is an African Court of Justice where some of you go. There is an East African Legislative Assembly where we send our representatives. We just don't know what happens there. But in all truth, is that this does not stop there. So there is something cooking that I think we should all first be alive to. The intention is to achieve a federation, and that we also set out to have a common market. So there is a common market that was achieved in 2010, 12 years ago. The next stage is to create a monetary union. Now, what some of you may not know is that the plan was to achieve this in some sort of way by July last year. And how have they done it? You know, to harmonize fiscal policy, harmonize certain approaches among the states. And that is already being done. For example, the reading of the budget. We all do it at the same time. I don't know whether we know that. That is a plan towards achieving some kind of fiscal harmonization. Now, what is happening now, at least as what I read, I think about sometime this week, is that the Secretariat was visiting Bank of Uganda with a view to establish an East African Monetary Institute in Uganda. The plan is to have, eventually to transform that into an East African Reserve Bank, a central bank. That is likely to be achieved around 2024. That's 2 years away, 24 months. So things are happening behind us that we need to know. Of course, there's a subject of political federation, the ideal. Already there's talk of a draft constitution. Maybe they even asked for your views and you didn't care. Yeah. So things are happening. It was expected that this would be available by end of last year. Of course, it hasn't. And now the idea is probably around 2023-24 to have a draft and have a debate and have that finally in place, the political federation framework finally in place. I dare say that in another 10 years, our country is going to be very, very different. Very different. Then there is the factor of DRC. I do not know whether you know DRC is keen to join. DRC is keen to join this federation. I think it has been approved. I think that's probably what yesterday's paper said. I think the application was handed in, and it's really a matter fait accompli. It's done. It's just the processes. Now, when DRC joins, it gets even more interesting. The land size of the East African community, as we know it, doubles. We'll be able to have access to ports from coast to coast. You know how the Americans say coast to coast? And then you probably have a West Coast gang and an East Coast gang. That's how we're going to do it here. Coast to coast. As a landlocked country, that is just miracles for us. The population goes up even further to nearly 300 million. When you see a population, think what? Market. And with that, we become the fourth most populous country, behind who? China and the US. Dynamics at play. But then there are potential members, people that are interested. The first one, interestingly, is Sudan. Sudan actually applied and was rejected earlier in the 90s, in the 2000s, because of the standoff between Uganda and Sudan. But now with the changes in that Sudan, will they still be interested? Maybe, maybe not, maybe. How about Somalia? Maybe. Ethiopia and Somalia, for all intents and purposes, are part of the federation. When they're building that grand dam, Renaissance Dam, who do they have in mind? Only Ethiopians? They'll probably come on their terms. So I raise this so that we have some context with this oil thing, the final investment decision, and finally down to insolvency. Sorry. Okay. Now, back to the discussion. How does this fit in the African context? This little graph, this little table, moved around quite a bit on social media, and I found it very interesting. It shows the growth of African economies in the last 20 years. You can see that South Africa has dominated this, and we all look to South Africa. It's the big boy on the continent, isn't it? But if the federation is to happen even in East Africa's state, the 6 countries, at 224 billion GDP, we'll have displaced Egypt. In another maybe 5 years, we could be number 1. Economies of scale at play. That's how this works. So, as a community, we start looking very attractive for investors. So now how do they merge? How does this then merge with the ECOP? If ECOP was only working for Uganda alone, trust me, we would be isolated. But we look more attractive when we're in the context of the community. In the broader context, we now are more attractive. We now have some sense of weight as a community together. So what are my thoughts about this ECOP? Talk is that there is oil on the other side of the Albert. Insecurity has not permitted the exploitation of that oil. You have UPDF there. You think it is fighting soldiers? You really think so? You know, I said things happen under radar. I would not be surprised if in a year or two there is an announcement that side that there are commercially viable deposits of oil, and therefore our pipeline will extend to DRC. That means this East African crude oil project will now have 3 of the 6 East African countries. If we're going to go by the numbers now, okay, 7. Okay, that would be 7. The ECOP, the community, do magic for DRC because for once there will be better regulation of their vast mineral resources. Better regulation, better exploitation, better rewards. That is not going to be championed entirely by the DRC. It's going to be determined by the diplomatic moves at play. We're building roads. We're pacifying the area, and so on and so forth. So suddenly you're going to be, even as a lawyer, you're going to have access to a sense of instructions that don't just talk to you, but also talk to what could be in Congo easily because of the union, because you can move around, and there's something that works for you that you do not know. You speak English. You speak English. The lingua of the world is English. Works for you. So we're going to see unprecedented business activity here of a scale we've never known. Already, hardly a week after signing of the final investment decision, Bentley, you know Bentley, the luxury car? Yeah, they were here shopping. So, what's the chance in your world life 10 years ago you thought you'd ever see a Bentley in this country? But here you are going to probably have a showroom. They're here doing their market studies. And yet they are not related to the oil. They are not. They know that you will buy it, you the lawyers, when you got swag, you restructuring professionals. So you're going to see more, I mean, even as these Mexicans and these Chinese come, these people who drill oil, what are they going to do? They're going to take breaks, do tourism, look around, visit. Huh? It's not just in Uganda, so it's going to be in Kenya. That's why I'm saying the region is going to benefit from this. Now, what happens with that is that there's going to be more integration, people to people. And soon, the political pressure to integrate is also going to come from down up. The people that are behind this may be visionary, but we are not really participating in it. But when you start making regular trips to Nairobi, you're going to be asking, but why is this border here? I don't want to be harassed. I can't be wasting time at the border. Why should I use a passport? Why? Sorry, my passport is being renewed. I lost my ID. Why? And soon you'll just be traveling. So it's now the pressure of the business, pressure of the people. It's being spurred by our oil. Okay? Now Uganda is going to have what you'd call fortune hunters. The people that are going to say it's hot. You see how our people normally go cheyo? Yeah? Within the region, the cheyo is going to be here. Because if you are just selling granules around a rich man's home, and you can set your price and he pays because he can afford, what's the problem? And so we are going to see so many of these sex workers, everybody. At least that's the expectation, you know? Yes, even drug dealers, everybody is going to be here because those guys are people that come with their habits. They have to snoot, and where the drugs and the money is going to come here, it's going to boom. Now, already in this context of the East African Federation is a sense of what I would call political jostling and military jostling. Uganda has achieved something unprecedented, in my view. Uganda's, your army, is in Congo. True? Is in Somalia. True? Southern Sudan? Maybe. Okay? But we have heard that it has gone as far as Central African Republic, Equatorial Guinea, and that the wounded soldiers are treated in Nairobi, in a hospital in Nairobi. So that means your country soldiers are in at least 6 African countries. Unprecedented. But now there's something else. Rwanda is now providing guarding services, pacifying services in the Central African Republic. It is in Mozambique. I read that as a kind of jostling for some sort of supremacy within the context of the African Federation. Rwanda cannot survive without the Federation. So closing borders and what have you, they can do that, but it's not sustainable, and they know it. It's not sustainable. Sooner or later, they will, whatever issues are between the people up there, they are going to sort it out. They just have to find a way. They have to be part of this solution. Okay? Now, this jostling, for me, speaks to the reality of what is behind the creation of this federation, the efforts that are actually at play. Now, when you have this sort of situation at play, it's going to bring in more money. The FDI, the money that is going to come here, already we're saying 10 billion. Economy is likely to grow to 50, 70, 80 billion. We do not have the capacity to generate that money ourselves. We're going to do it on credit. It's money coming from abroad. And the first risk is this systematic global economic shocks. If you remember in 2008, 2007, there was a global crisis here, international. Were we affected as Uganda? No. Because you don't have a lot of global money. Number two, you are really a cash economy. You pay cash, you know? So the systematic shocks there did not affect us because we were okay. But with foreign money coming in and layers of instructions, or layers of businesses coming in or expanding into the economy here, we are exposing ourselves to those shocks. So when the prices of the war breaks out in Ukraine and the big financial capitals shake, the tremors will actually be felt here. And that is where insolvency will come into play there. Because of this financial investment decision, and because of the money that is going to come in, we envisioned Kampala and Dar es Salaam have an opportunity, if we play it right, to actually be financial hubs, commercial hubs within the region. Maybe to the level of Nairobi, maybe even beyond the level of Nairobi. But I say Kampala has an advantage. Why? You speak English. Two, for whatever you may think, your work ethics are better than the Tanzanians. You are not as stubborn and as the Tanzanians. So you play it right, and the money keeps coming here, and you're productive. It is going to be that big. We're not dealing with $3 to $1 million anymore. We're going to be dealing with people that have really significant monies at stake. Significant. In the context of the East African region, it's very likely that from your office, wherever you may be, you could easily be given instructions to deal with a mine with 100 million worth of gold in Congo. It's going to be that sort of big. So in other words, the same, stakes are high, things, defaults are big. So what is likely to be lost is also significant. Because of the systematic effects and money not coming from abroad, you'll have subsidiaries here, maybe branches set anywhere. You're likely to see a lot more cross-border insolvencies or cross-border restructures. All of them big. There's nothing going, very little is likely to be small. Now, obviously, that means that whoever comes here, the people, as the investors come here and whoever is starting, but I want to emphasize that if we play our cards right, as a country, if we play our cards right, there's going to be certain demands for certain minimum standards. Corporate governance, the way your courts behave, or even you, as you present yourself and talk, there's going to be an assessment. Do we trust her or not? Should we give her a bone or the beef? There's going to be that discussion. Okay? There's going to be that discussion. And now, because this money is not ours, it's coming from the foreign capitals, international restructuring firms, whether they're lawyers, accountants, they're all going to come here. So you'll soon see SRM, Bracholi, and so on, and you'll wonder where they are, but they are big in Hong Kong. The big players, and they will proudly say, we have an office in Kampala. This is the implication of this sort of thing. So I submit that the restructures won't die. They are just going to come differently. You may never have a receiver ever, yes, but you're going to be advisors on restructuring processes, on mergers. You're going to be advisors on administration, basically how to deal around. These stresses are going to continue. These stresses are caused by many things. Death, the death of the vision leader dies and that's it. Fraud, that's going to continue. It's going to continue. But how we conduct ourselves in advising companies out of this distressful situation determines whether we benefit from this or the international firms work somewhere and they just give you a certain form to tick. Do you have a law? Yes, tick. Does it say this? Yes, no. How would you advise in 2 sentences? And then you get your $1,000 and you think you're big. No. Yeah. So, what do you have to do? What do you have to do to benefit from this? You're going to have your game. As a country, we have to up our game. We will lose this if we don't. We have to be great at what we do. Deliberately, that takes, for that number one, I'm talking about our mindset. Be seen and stand out. Stand out for what? If you're going to call judges obscene names, that's what you'll stand out for. And damn, you'll be great. The hit on social media. But if you're going to stand out because of your knowledge in this particular area, this is the moment. This is it. And I dare say again that you all can. When I look around, there are many of you that are great lawyers. I stand and pale in your shadows. But what you're standing out for may not be it, honestly. So we need to upgrade our restructuring skills. Understand how these things work. Let's not have guesswork. Let's think bigger as a country. Let's think bigger as individuals. Whether you're a judge or a lawyer, think differently when you're talking to these people, because they determine whether they come. It determines whether they stay or they hide their money elsewhere. The opportunities in this are many. Opportunities, for example, in restructuring ADR. Why do we spend so much time in the courts? And look at what the courts are doing. Those two have to up their game. His Lordship Sekana was talking about this ATM case. Now you tell me who is going to be a liquidator after that. In this Crane Bank case, what's going on? What message are you sending to the owners of this money? When a secured lender enforces this security after trying so many times, at stake is $40 million. And then you say, by those standards aside, this man will talk to you in 6 months. Are we going to find any assets? What are we telling that investor? Sorry, your $20 million may have been down the drain. And he's going to say, is this what going through? No, let me stay in Nairobi. Or if I have to stay, I have to cost this. And then we have a discussion about high interest rates. Have we ever known that we have a role in actually maintaining those interest rates as high as they are? Yeah. Because you're not participating in the solution of the problem, you're exasperating it because you've got your money, 3 million. How cheap? That's how we're going to have to think differently. Find regional international partners. You're not going to go this alone. There's money for everyone. Even in the restructuring process alone, there is money. The instructions, first of all, are likely to come from where? Up there. In London, in New York, Hong Kong, Singapore. The major financial hubs. Maybe Johannesburg. That's where the money is. If you want to be part of this, this is what you're going to do. find those partners, build your knowledge base and skill base, and then position yourself. Find solutions for our regulatory reform and regulatory framework. Why? The law is weak in some respects. Can we all join hands to make it progressive? We have an opportunity, by the way, to be a restructuring hub in the region. No one is thinking like this. London dominated the East African Union, the European Union, because of the very user-friendly law it put in place. Every lawyer knew his role. And so every restructuring that had to be done in Europe ran to the London courts. That meant more money for who? For every lawyer. But when you throw rocks at this, and because you've got 3 billion 10, that's where you'll stay, 3 billion 10, and then periods of drought and clap on you, instead of creating a situation that just rains money. So the courts too have got to style up when they give these sorts of rulings. This Diamond Trust case, and guys are scratching their heads and saying, are you saying that I've lost that money? For us who are in those international circles, and I ask you, please, gentlemen, come and hear for yourself. It's very hard to defend. So please help participate in solutions, finding solutions. Let's be progressive in our approach. The official receiver's office, how big is it? Yes, we have a directorate, but are we ready for this? For this bigness that is coming very bigly. With those few words, ladies and gentlemen, I would say thank you. I believe lunch is ready.
A round of applause for Mr. Kabito. Thank you very much. I'd like to say thank you for the... Okay.
I am interested in being vigilant, and also, I'm interested in being vigilant and usurping opportunities that this ECOP and the East African Federation brings as an aspiring insolvency practitioner. What is your say on my suggestion that URSB as a board, wouldn't it be viable to have an East African insolvency board of practitioners, whereby if I'm a certified insolvency practitioner in Uganda, I can be able to have instructions of an entity from Kenya or Nairobi or DRC with time, whereby practice is easier cross-border. If we work on that mechanism, isn't it better to give us opportunities in our field? I just want senior counsel to have a say on that, if my suggestion makes sense or not, for the future opportunities that he has interested us in. I thank you so much.
Thank you. Thank you so much. He has noted that question. Next person. Yes, Hamidu. Please introduce yourself and give us your question, and kindly keep it brief. Thank you.
Yes, thank you very much. My name is Laston Gulume. My appreciation to Mr. Kabito Karamaji. My question is in respect of the recommendations that he made. What do we need to do as we prepare for the opportunities that are coming with the ECOP? And I just want to pick his mind or get any practical suggestions from him before we move maybe to the hanging out with the big boys, getting to the international scene and the international players. What do you, from your experience, since you've been around this these discussions? What can we do leaving this conference today that can help us at an individual level as insolvency practitioners to set ourselves up for things that are happening under the radar and will be manifesting a couple of few years down the road, in terms of any trainings, in terms of any certifications past just having the qualifications of an insolvency practitioner? Are there any recommendations you may have? Thank you so much.
Thank you. Our final question, please. Gender balance? Okay. My colleagues, do we have any questions from online? Rachel, you can take the microphone and read us the question, please.
There's a question from an anonymous attendee. He's asking that how does he, as a legal practitioner, stand out in practice, in insolvency practice, given that there are so many professionals who have more expertise than most of the lawyers in the field?
Thank you. Is that all, Rachel? Okay. Thank you very much. So we have 3 questions. I'm requesting you to. Okay.
Thank you. I kind of was seated on tenterhooks. You know, normally after presentations, I fear the questions that come. Sometimes I think I present myself cleverer than I really am. So let's see how I fare in this round. Jesse, you've asked a question. How do you, about the creation of an East African insolvency board that can certify this? I think it's inevitable. It's going to happen. I think it's inevitable. Really, first of all, because we have, we now have free movement. The creation of this federation is going to allow for free movement of labor. Already with the lawyers, we have challenges with this mutual recognition agreement because we are still territorial in mind. And I think for Uganda, we are probably scared of the aggressive Kenyans. And they have a few things in their favor because the financial hub is in Kenya. Nairobi is the financial hub. Decisions are made there. So if they come here, we may be disadvantaged. But with the crude oil, you know, we have an opportunity now to level up. We have an opportunity to level up. So I think that this is going to be inevitable. Either that, the creation of some kind of board, or some kind of mutual recognition. The official receivers are going to have some discussion on that. And for me, quite frankly, the sooner this discussion starts, the better. Let's not wait for the buffet. Let's participate in the choice of the food to be cooked. So I would say that that discussion is going to happen. It's inevitable. Last on Mugulume, what should be done to prepare for these opportunities in oil? And what should we specifically do before we deal with the big boys? Now let's first understand what the big boys normally ask. They're going to ask skill. They come to you because they have been exposed to this, and for them, in fact, for you, you are running around dealing with land, title, what have you. For them, they only breathe and deal with structures. So that's what they do Monday to Monday, you know, 8 to 8, that sort of thing. So I think for number one, take interest. Take interest in the subject and then get the requisite skills. The training opportunity, and insolvency is one of those, unfortunately, that doesn't have, you don't have a lot of LLMs in insolvency. They're not lying around. They're there, but even then they are probably not that adequate because it's a bit of like a practical. You need to be quite practical. You don't come with an LLM and think that you suddenly manage a failing business or give advice on how to restructure business. It doesn't kind of work like that. So some of the things you need to go through go through the finance itself. What I would suggest for me, first of all, take interest, get the skills, read up. I am a member of Insol International. That is, for me, why I found a lot of the readily available knowledge and also the kind of people that that boosted the confidence that I have today. Initially, I was a member of IBA. They have an insolvency and restructuring section. It's a very small thing, and I did a lot of trips. Quite frankly, I think I wasted a lot of money because it's a small group of about maybe 30 peeps, very senior people, and younger, maybe about 100. It does give you a sense that, okay, you are in a bit of an exclusive club, and I did feel that at the beginning, especially because in some of those conferences I was the only African, and I had to go through some kind of inquisition. What are you doing here? What do you really want? What are you looking for? And then I was suggesting back then, of course, when you're young and ambitious, and saying, guys, what's your plan for Africa? Africa is the new, what is your plan? Can we, what do you have? And all the while they gave me this impression, Insol, they have accountants there, it's more accounting, and that's the impression I had. So, but I used to get a lot of invitations from Insol that I didn't take seriously. It just happened that Insol once had a meeting in Nairobi and I was invited. So I said, well, it's just Nairobi here, let me go and see what it's like. I've never gone back to IBA. I found Insol more practical. They have programs for Africa. They have trainings, the fellowship that I did. Rita is here. I don't know whether she's still here. She just finished the fellowship. So the courses that you do there are more practical. And I just fell in love with this all. I feel at home. And I when I speak, I'm not valued. No one is looking you up and saying, well, what are you really looking for here? I don't have that challenge. So Insol is one of those to join. There are other institutes, the Institute of Insolvency Law, I think it's called that. There are others. We have a kind of growing association. I'm sure Mr. Bakayana, the president, is here. We also have to put our act together to see how to offer training programs for local practitioners. I know that there's a plan a discussion going on with LDC and others to create a program, a specific program for practitioners, young practitioners like you, Laston. So that answers the question of whether you have the skills or not. You do. You have a fair understanding of finance and figures. You have some kind of leadership skills. You can project and see where situations should go. That sort of discussion. The other, of course, the big one is integrity. And integrity starts from what we do every day. Every day. Do you deliver on your promise? When you tell your sweetheart, I'll be home at 9, do you actually turn up at 9? Why I say it starts from there is because it then permeates, it's the ability to keep the promise. It's when you tell a client, I'll be there at 9 and you're coming at 10, or there's already a problem. These guys don't work like that. They like it when you're available, you're accessible. And what you have for you, by the way, is that the fact is that you're on the ground. You're on the ground. So if you have a fairly good network that can open doors, even better. So your social circles, is it just about football? Is it just football and I don't know what else you discuss on your WhatsApp, that sort of thing. So you want to grow your network and let it be of value. You need to stand out. You need to invest in yourself. That's the beginning part for you. The qualifications, the Global Insolvency Practice course I did led to a fellowship, but there's also an LLM with Insol. The fellowship was a program. It spanned how many jurisdictions? Maybe 12, probably 15. Studying insolvency systems around 15 jurisdictions. It was very practical, had judges in it, as some of my teachers, practitioners from the big markets, as you know them, and it did open the door. We had moot cases before real judges, and that's also there's that one. There's the LLM. They also have that. It's got a practical element as well. So I would ask, for me, Insol works for me, and I know that there are other LLM insolvency cases, but there are some of those universities are not yet recognized because people quite haven't taken insolvency seriously. Yeah. How does one stand out? The question online. The last one, how do you stand out? Stand out really depends. It's how you want to brand yourself. The quality of discussions you have, the kind of skill you have, and how you show it and how you demonstrate it. How do you better yourself? If you want to go then to a plainer level, is that do you look for opportunities like this to speak? Do you stand up to ask? And then everyone says, but who is that guy? He asks many questions. That's so good, you're standing out. Initially, at the beginning, everyone just kind of says, oh, he asked many questions. But if you know what you're doing, you're okay, you're okay. You're right, articles, right. Look, no one has written about Crane Bank. Effectively, no one. No one has written about what else? ATM. No one is leading these discussions. I ran something with a couple of friends on the cluster. At some point, we were looking for speakers. And I said, even young people, just come. So that is what you want to do. And the other thing is, young people, I want to believe this online person is a young person asking to stand out. Get mentors. Some of you guys believe that you will find your way. I used to think like that also, until I found myself bumping into walls. The corridors of life need a hand, and you need to have the right hand. The good thing is that you choose who your mentors are. So get the right mentors, and they grow you. They speak for you. That's the way the journey of life is. Yeah. I want to think lunch is ready. Yes, my plea to leave before someone asks a hard question.
Thank you very much. You may now leave. Thank you. Please appreciate him. Thank you, Mr. Kabito. We appreciate you so much. And he's always been a partner of URSB together with the firm, and we really appreciate your generosity to share this insightful information. So we're breaking off for lunch, ladies and gentlemen. Our lunch will be served in Kazinga restaurant, which is just outside, just behind this building, as you go through the walkway that we came through. So kindly, you will find ushers to give you the coupons and also guide you to the lunch area. I just want to inform you, I'm sure you have the program, but in the afternoon we'll have two presenters. One will be about corporate governance practices essential to avoid insolvency, and that will be presented by Ms. Rita Kabatunzi, as I earlier said. And then the second one will be about stakeholder management and communication for effective insolvency administration. Please do not leave. I know it will be very beneficial, and then we'll have the remarks as we close. So kindly return. And I'm requesting, because we've overshot by about 30 minutes, I'm requesting that we kindly use about 45 minutes. So if we can be back here by 2:15, so we can resume and be able to leave early. Thank you very much. We'll see you in 45 minutes. The coupons will be given at the restaurant. Thank you.
Good afternoon, participants. Welcome back to the afternoon session of the Insolvency Conference 2022. Hope you had a good lunch and you're ready to take off for the afternoon session. I know after lunch it can be a bit difficult to keep you awake, but our first presenter for the afternoon will have a very interesting conversation. Our presenter is Ms. Rita Kabatunzi. She's a company secretary of Stanbic Uganda Holdings Limited and its subsidiaries including Stanbic Bank. She's an advocate and chartered governance professional. Her career in corporate practice spans over 15 years. Rita is a fellow of the Chartered Governance Institute, UK, founding member of ICSA Uganda branch, and a member of the Africa List, a mentorship platform for emerging business leaders in Africa. She's an accredited trainer of International Finance Corporation, IFC, with training and consultancy experience in Uganda, Kenya, Nigeria, and South Africa. She previously tutored for the ICSA Professional Qualifying Scheme on corporate secretarial, corporate and business law, corporate governance, and strategy. Ladies and gentlemen, please help me welcome Ms. Rita Kabatunzi to the podium.
Good afternoon. As we try to get to I think I'll give the Registrar General a moment and the Honorable Justice before I start, if you will allow me, as well as the Chairman. Oh, sorry, that's Councillor Nerima. Sorry, the masks are very confusing, so yeah. So good afternoon to us all. Allow me to take all protocols observed. As has been mentioned, my main expertise is in business administration. And listening to the speakers this morning, I was a bit worried. I actually had a conversation with Alan around, are we sure that we needed to be discussing this topic today? So I've changed the format somewhat. I know we are pressed for time, but I also know that some of what I would have said has already been discussed, of slides to the appendix, so you will get them. So the detail on corporate governance and all that, I'll not go into every single bit of detail. However, I will allow for questions, and hopefully by the time we're done, we'll have met the objectives of this session. So that, sure, that's fine. The trick with corporate governance is everyone thinks they know what it is. We all think we know what it is, and my passion, as has been said, because of my background with ICSA, is to demystify some of that. So if we could just go back to the first slide. And in doing that, to get us to understand that corporate governance is not about codes and practices. You're not going to hear me saying, oh, table F, or, you know, I won't center on that. What we want to look at is, if businesses are failing, what is causing them to fail, and where in corporate governance could the problem be? Now, I'm aware that these are insolvency practitioners, so I'm going to continue with the theme that we had this morning, which is to challenge you. As the theme of the conference says, emerging trends in corporate restructuring. Things are no longer what they are. You will see that there are slides in there that say to you, look, before you'd go to a court, and I think the Honorable Justice mentioned this, it's not as obvious as it used to be. So if you go in to claim what belongs to your client, and you're not aware that there are other balancing interests, you might not get the result that you would like to get. So what I hope to do is give you some practical insights into business administration. Yes, I know it may not be the thing that we would have wanted to do at this time of day, but hopefully we can keep it interesting and short. I'm going to try and still keep within the time that was allocated to me, keeping in mind that I have the graveyard shift. I hope that's okay. So this is the first slide that I want to give us context. When you are thinking about your client, many times you're thinking about one particular aspect. Okay, either it's the shareholder, it's the person who's owed money. I like Bob Tricker because he has this way of explaining things in a very simple way. So this is the context for what I'd like us to discuss. We've talked a lot about corporate rescue. We've talked about the fact that interests will be balanced. This is why. This is why. Corporate governance has permeated every single aspect of business. It doesn't matter whether you agree with it or not. It's not about codes. It's about balancing the interests of these different stakeholders. So if you look at this slide, you have, just ignore the directors 8, that was a presumption, but if you have, say, 8 directors, you see you have a circle, okay? You have an inner circle, you have an outer circle, you have a triangle. What you have is an interplay of the board, management, shareholders, and all of these are somehow tied to the people that you represent when you want to recover money, okay? Recover investment. You're thinking about the data, giving what is right to your client. But this is how corporate governance looks at this situation. Why is this important? If we could go to the next slide. Because in corporate governance, you do not look at one side. The thinking is, if I looked at only one side, there's a lot of other players who are not going to get what is due to them. Never mind that they haven't invested. They are called stakeholders. All of these are important. So I thought I would put this slide in for context to say, as we make this case, maybe you are skeptic, maybe you think it's about codes and practices. As we make this case for corporate governance, I'd like you to think about some of these and see whether, in fact, they are not concerns that anyone would have around business. Because if they are, it's a compelling case that you cannot ignore corporate governance. It will come up. Later on, you will see that, by the way, this structure may actually work for you as an insolvency practitioner. It may actually tell you what to go in and check for to build your arguments that those in charge did not do what they were supposed to do, so they are not fit to run the business. Maybe it should be rescued. So keep that in mind. Keep that context in mind. So it's concerned with running the business and keeping it healthy. How different is that from corporate rescue? Not very different. It's about saying, yes, debts are not being paid as and when they are due, but there are several stakeholders who may also have a stake who we cannot totally ignore. And I think Honorable Justice said it very well this morning. It's changed. Even the courts don't just take one position. Yes, I'm a secured creditor. Yes, we have the agreement. Yes, I can see that the director has breached what they were supposed to do. But the sustainability requires that you think about the impact of what an action towards insolvency might take, especially if you're talking about liquidation. That's why you see administration has become such a catchphrase for corporate rescue. So I'll not go into this, as I said. We will be sharing the slides, but I wanted you to see at the bottom in the blue. It is applicable at all stages. Corporate governance doesn't die. even when the liquidator takes over, there is still a sense that you have to have played by some governance rules. Later on, maybe I'll speak to what those are. If we could go to the next slide. Sorry, I don't have the clicker, so I'm going to keep saying that. Just bear with me. Next slide, please. So the impact, and I've just summarized this because there's been a lot of discussion today, and I do not want to center on what has already been discussed. But in that box on the corner side is going to be the basis of my approach to telling you about corporate governance. It is the fact that there's a knock-on effect for every business failure. Yeah, that is how business administration looks at it. There is a knock-on effect to the financiers. By the way, someone talked about the banks. The banks hold customers' deposits. It's not their money. So the banks are saying, look, you need to give us some sort of sense to get a cut so that we can return what is ours. The customers are saying, this entity was serving us. The suppliers are saying, look, if you think about Nakumat, we actually already gave them our goods and we rely on this. It's part of our operating capital. What do you want us to do? The livelihood of employees, a lot of stories eventually end up with the employees who are left with no job, the livelihood was lost. So I want us to keep that in mind because, again, I'm mindful that we are thinking about our client who many times is a secured creditor, okay? But it's not just your client, at least not as far as governance is concerned. So the thought process around this is how much are you able to change? How much are you able to reinvent and shift your mind to still make the best out of a situation where, yes, a business is not doing well, but maybe, just maybe, corporate rescue might be better than having it wound up, or yes, they can't pay the debts, but I see an alignment between the way the courts are going and what corporate governance says. So I just want us to have that sense as we go through. So I'm not a practitioner who's telling you about codes and practices. I'm just telling you about how things are unfolding in line with the emerging trends. Next slide, please. Again, I'm going to try and balance between rushing, so that we make up some time, but also having enough time for discussions. Apologies where you see the slides are sort of just white. I noticed I was sitting at the back that we couldn't see some of the words, so I changed that format. So here are key concerns when it comes to corporate governance. Agency dilemma. We all know who agents are. The shareholders do not run the company. They actually appoint people to run the company on their behalf. Therein lies the problem. These people, who we will call the board of directors, also then delegate authority to management. Now, if these boards are not the ones running the company, how are they making sure that the company is being run, managed properly? What do they actually have as a basis for making the decisions that they make? Because that is the agency dilemma, that the people who are running the entity, and sorry to all the managers who are here, I'm a manager myself, but it's been said in corporate governance that there's a lot of conflict between the interests that a manager has, yeah, and those of the ultimate owner and the stakeholder. Therefore, there must be a framework for managing them. How is that connected to insolvency practicing? We'll talk about that a bit later. So questionable dealings, a lot of cases have been given today, so I'm not going to repeat the cases. I'm just summarizing for you. This is where the key concerns are. And they are the same in insolvency as they are in corporate governance, okay? Unethical leaders or ineffective leaders, they are not always fraudulent. Corporate governance actually takes note of that, and you'll see when we talk about the duties why that is the case. The directors don't always have all the information to make the decisions. So the other is culture. A lot of our companies in Uganda, from the corporate governance side, what we see that is quite shocking is how many times management will go to the board and manage to walk away with a decision literally with only half the relevant information they should have had. That is a very big governance problem because it means management will steer the board to where it wants to go. Excessive risk-taking. Later on, you will see, before we jump at the directors who take risks, we must also understand that the way business works, it's risk and reward. So when we are looking at the risks these directors took, there should be a context for why they took those decisions. And then non-effective escalation procedures. This one is a big one. Copy and paste policies. I don't know how many of you, if you've had to discover the policies that these companies have been working under, you'd be surprised to find that even things like the industry that is in the policy is not for the company because they did a copy and paste job. So those are the key concerns. When you look at insolvency, many times these are the things that are delved in the process of investigation. Next slide, please. So, if you want to see whether corporate governance has been upheld, a very simple summary here, okay? So, I think we all notice this is a house, yeah? It's structured in the form of a house, and that is because the thinking is, at the foundation of any company that is well-governed is ethics and culture. At the foundation is ethics and culture. However, it sits on these 5 pillars. If it is a well-governed company, why is this important? Because when you go before a court or an arbitrator to argue your matter, you're not going, and I think this point was made in the morning, you're not just going to say they failed to pay. There's going to be, they're going to look at how was the business being run. Now, if the business was being run in a rather sound way, there's a big chance that maybe the directors will be gotten for things like wrongful trading, but you may not necessarily walk away with the result you want. Why am I emphasizing this? Because there's a reason why corporate rescue is increasingly at the forefront as opposed to winding up and liquidation. So those are the 5 principles. Again, I have put the detail in the slides, in the appendix. I'll not go through this, but keep this in mind. Keep this in mind. This is my counter if you find me on the other side of an argument for a business to be closed. Was the board practicing what they're supposed to practice? Were the controls in place and were they being followed? Was there good citizenship? This one is not so big when it comes to insolvency. Was there disclosure and transparency? And what was the relationship between the shareholders and the stakeholders? It is not just about the shareholders. That's the takeaway from this. This is not a diagram I drew on my own. This is an IFC model from the board leadership kit. So if you can use this to summarize in your mind, it helps you to understand what we mean when we talk about good corporate governance. Because you're going to later on start talking about directors' duties. They do not come from nowhere. They're actually entrenched in this. So you have to understand the basis of why these director duties came up. Next slide, please. So the stakeholder is at the center of everything now. It's just the way the world is moving. We've talked about corporate rescue. Corporate governance is no different. Corporate governance used to say, return the shareholder's money. The shareholder is king or queen. Now, the same people who've been coming up with this thought leadership are saying, but what about the wider community, the people who deserve to also have some return of some sort, even if it wasn't financial? So a part of what I put here, I think, is there was a quote in the Nakumatt case. I got this from the Standard newspaper. So the judge in that case last year extended administration in Kenya and said, assets need to be managed for the benefit of the retail chain. The retail chain is not necessarily the secured, but the judge is still saying, let's extend administration. Let's extend it a little bit. UTL, same story. So what is that trend telling you about how you approach insolvency? Yes, a lot of the time, there used to be, when we studied insolvency, there was a whole hierarchy. If you're secured, you get taken care of first, or I have a floating charge, you know, I'm fine. Official receiver, I'm done, I'm good. It doesn't matter. Those who didn't secure themselves, didn't secure themselves. The thinking now is there's a lot more effort to try and prioritize everyone. Keep in mind that the shareholder is actually at the bottom of this rung, the person who invested. So if you remember the agency principle, the question is, does this shareholder deserve to not have anything? They are the ones who invested. But along the way, this agency problem meant someone was running the business and didn't run it quite well. And I think even in the arbitration, I don't know, I look forward to listening to Senior Counsel Nerima. There is a sense around that, okay, there's a dispute, but can't these businesses be salvaged? The next. Thank you. So this is my favorite approach to corporate governance, because as a business administrator, I prefer a practical approach. So this approach is from King. It is as close to an Africanized approach as we get. Yeah, we tend to use UK a lot, but I like to use this version. Why? It speaks the most to insolvency. Because it says, look at the leadership, look at whether there was an effort to run this in a way that you're not just declaring false results so that you have profits and good accounts, but you're thinking about the fact that this needs to carry on for a few years. So I don't want to attract investors when there's really nothing to do, or I don't want to siphon what funds have been entrusted with. So ethics and leadership sits at the heart of the way King says we should run. Again, bear with me, because when we get to the insolvency practitioner part, this is not removed from the arguments you'd be asked to make. So the other issue is I want to see whether there was adequate control and oversight. If it was there, then the director has a much better chance of getting corporate rescue. So you may be very sure of yourself, you have all your documents. Yes, they entered the contract, they haven't paid us. Yes, they signed off on the deed, they haven't paid us. But then there will be a thinking around this. Value creation in a sustainable manner. That's what a director is expected to always be thinking about. And then, of course, we've talked about trust and confidence in the company. We know that that is always a big issue. So if directors are running a company in such a way that they are not concerned at all about who they're entering into deals with, you know, the impact of certain arrangements, then there is a good chance that you as an insolvency practitioner may make a stronger case. So corporate governance is about responsible, effective, transparent, and accountable leadership. When I stand here talking to you about corporate governance, that's what I'm talking about. Not codes, not that those are not important. That's called the normative side of behavior of corporate governance. What we are looking at is the people in charge. How are they running the show? Next slide. So I actually picked this from Honorable Justice this morning because it actually makes the point that needs to be made, which is that there's a need to strike a balance. It is not just about, I want this for my particular client. That's not the way the people who are deciding these cases are deciding them anymore. And they will look at this aspect. So at the heart of the hope for health and business is how corporate governance is working. So it's increasingly, corporate rescue is increasingly at the forefront. So if you're an insolvency practitioner who is trying to build a career off of representing secured creditors because they used to really have a very good case in the past, things have changed a bit. And I just thought that we should make sure that we understand that. Next slide. So I think I've made this point. I won't strike on it, but it's to just let you know that there is a recognition that there are competing tensions. It's not as simple as blaming the directors all the time. That's not to say that the directors are not wrong. There are cases you will see where they are. But there is competing interests. So the question is, were these balanced, and was everything done to make sure that the best possible return was given for these different entities? Next slide. So I am sure the people at the back can't see this, but I couldn't alter it. So I'm not going to get into detail on it, but this is the point. When you are considering who has done wrong, the role of the board and the role of management is different. I have read many cases where directors are being blamed for things that were the role of the management. Now, does that mean the board is not ultimately responsible? It is, but how you present your case is compelling. If you look at case law on director duties, it's not very easy for directors to be found liable. The reason is because there's the principle of hindsight. In hindsight, we all could do better. In hindsight, we all know what we should have done. But in the moment, I who is there having to make a decision to help this business to continue to be healthy, what am I relying on? Am I being negligent? Am I being careless? Am I being fraudulent? If I'm not, is there a chance that you can still just say, you still got it wrong, the company is insolvent, so you're in trouble? Management many times, and I'm sorry again if you're in management, management many times does not make the job of the board member easy. So as we are shooting, let's remember that management is the one running the business. Management is the one running the business. So when you're focusing on the players, in why this company has gone down, in making your arguments, please remember to make that distinction, because the courts are going to make it. They understand corporate law, and the case law is there to this effect. Next slide. So the overall role of the board, which ties into the director duties, the one that they cannot get away from, the one they can't say management should have done this, you know, the one they'll be assessed against is acting in the best interests of the company. And we will see what that is. There's a lot of case law on acting in the best interests of the company. Avoiding entering transactions that will place the director in a conflict of interest situation. When I was reading the case of Spencon, the Spencon case in Kenya, the construction company, these directors were living as though, and they had been brought on, the administrators who were then sitting on the board, they were living as though they had come to just earn a salary. They had forgotten, actually, that they were there to rescue this business, and the level of impunity was to some, those ones cannot, it's very, very difficult for those directors. Actually, they fled. I don't know, maybe now something has happened, but from what I knew, because they couldn't explain why they were entering some of the transactions they entered. And we all know the language of swell the assets, you know, look at whether there was preferential treatment given to certain creditors, avoid certain contracts. All of that is because there's a recognition that someone may not have done their job. And if they didn't do their job, then maybe they deserve to be liable. But if they did, with the information that they had available, your chances become slightly less, yeah? It's likely that they'll be given another chance to stretch the business, swell the assets, give as much as possible. And we've seen UTL is still not yet liquidated, yeah? That's the position. And I think someone made, I think it was Kabito in the morning, who made the point around, you have to start thinking about this practice as very different from what it was. It's not as simple as saying these directors didn't do their job, therefore, you know, my client needs to get their money and the rest who are not secured, well, that's their problem. It's not that simple. So reasonable care, skill, and knowledge, I think, is a very well-known principle. Even we as lawyers have it. I'll talk about it in the slide on duty of standard and care. So this is going to be the big one for getting the directors. And this is now me speaking as, you know, one who understands that maybe sometimes someone hasn't done their job. This is going to be the big one. And you have to be able to argue it out. It is not as obvious as we think. It's not, oh, prima facie, this, you know, the business has failed, therefore, this was not done. These directors were asleep. It's not that simple. I guess a class in corporate law, the people who teach corporate law would be able to elucidate. That's like a whole day's class on director duties, especially around duty of skill and care. The next slide, please. I will share the slides. I'm very, very mindful that we are trying to compress the time. I know there will be time for us to have the discussion, so I'll answer some of the questions there. So the board, at the heart of a lot of challenges with not being able to pay debt, the big question that people ask is, why did the board approve that transaction? Why did they approve that transaction? And some of these directors have been quoted as saying, that's the information we had. We wanted to at least rescue the business. It looked like a good, you know, business for us to do. And so part of what governance says is, when you're making that decision as a director, are you testing the assumptions? What makes you believe that this business is actually, this client is going to be able to pay? What makes you think that actually, by entering this contract, you're actually going to swell the assets or make it better for the ultimate owner? What makes you say that it's better to continue at this point when you have all the facts? One of the things that has been found, I'm not too sure about Uganda, but the trends in many other countries is that you find directors making decisions and they have no idea what assumptions are. So you have a CFO who comes in with assumptions, or a executive who comes in with assumptions, and they believe that they say, because there's no one on the board to actually challenge this person and say that is in that assumption rather, you know, false. If, for example, right now with COVID and if a board is overseeing the business of struggling, there should be some assumptions that you should not allow. For example, we'll be able to turn around this business in 6 months. A good board member would ask why. What is different? We are still recovering from COVID. Why would you think that you'll be able to get what you didn't have in this period of time? That's what testing assumptions is. If you can show that, you have a good chance as a director of at least your company being stretched. The other I wanted to talk about is appetite, risk appetite. No accountants, I think the accountants in the room at least will know this. I don't know if you actually pay attention to the fact that business principles run on the basis of risk appetite. So what will happen is that there are some companies that have, in fact, defined their risk appetite as quite high. Okay? It has been approved by the board. Management has explained and said, in order for us to win this business, we have to go in. We have no choice. We have to go in. And they've justified why. They've shown the forecasts, the presentations, and so they have a compelling case that the board then says, okay, let's go with that based on our appetite. We have defined that for us, we are a bit more willing to take risks. Now, if you come in and you say that these directors have not done their job, when there's a defined risk appetite within which they operated, from a governance point, yeah, the directors are supposed to ensure there's an effective risk management framework, which includes defining what the risk appetite is. So if it's defined, the director is going to say, but this is what we collectively agreed. So is this actually, was I in breach? Was I at fault? We need to remember that, you know, this is an entity, people have invested in it, they've decided on a certain strategy. When things go wrong, it is not always the case that you're going to say, you failed to pay, therefore. Sometimes I fail to pay now, but I could pay in a year, depending on the case. You want to take that into account, especially as your cases start to go more and more into arbitration. It's not really just hard and cast that, you know, if they fail to pay, then we are in trouble. So maybe I'll go to the next one. So I think I've spoken to this. The only one at the bottom that I'll speak to is now as a person who works in-house, is sometimes, and this is an argument that directors use all the time when companies go bust, sometimes they say, we did not know. The information did not get to us. That is called the glass ceiling dilemma. The people who actually want their proposals passed are the people who control the information. So when they come to bring this proposal to the board, they will present it many times. If you look, really delve at where the problems come from, they will present it in a favorable way. They will leave out whatever they feel will skew the discussion. So the question is, what then are the directors supposed to do in that case? Someone will say, leave the board. I don't know if Emily is still around. I know that is a principle we talk about a lot. As a director, you might want to get to a certain point and say, leave the board. But this is a general problem, people, even for the well-run entities. The fact that information does not always flow the way it should. People say, oh, they didn't have quality directors. You can have quality directors who are sitting and deliberating matters and still not have all the pieces to make the decision. If we could move on to the next slide. So I just thought I would put this here. We don't have to go into detail on it, but this is the decision conundrum for a director. Success depends on sound judgments and balancing different interests. That's one. The other is that risk equals reward. Sometimes the same people who are crucifying the directors are the ones who are asking them why they are not taking the risks to improve the return. I'm not saying all the time, sometimes. Risk versus reward. Short term versus long term. Am I going for the long haul? Am I going for the short haul? If I'm going for the long haul, if I fail to pay debts in the first year, are we in trouble? So that's a going concern. Your debts are not being paid as and when they arise. Am I in trouble? What was our strategy to start with? Effective oversight, we've talked about that. I think just at the bottom there, a good board ensures a balanced evaluation. That's what the board is there for. That's what the board is there for. It may not be what we ideally want. Now I'm talking as a person who's on the corporate governance side and on the business administration side. By the way, just to be clear, I'm not saying we should let directors go rogue. No. I'm saying there is a context that is increasingly showing up in how decisions to have cases passed on to an administrator as opposed to a liquidator. There is a trend for why that is happening. There's a recognition that maybe this business can be saved, maybe the context wasn't right, maybe someone else could run it and save it. Yeah? And all of that is recognized in corporate governance. The fact that the directors are answerable to the investors and the investors want a return. The question is, how much risk can I take? How much risk can I take? And when the rewards are good, no one will complain. It's when things go wrong, and the directors have to constantly balance that. I feel like I'm talking to, but it's from the business administration side. I know it will all tie in. So as you go in to look at these boards and you're saying, oh, this board hasn't performed, this board has a problem, this board is not effective, I just thought I'd put this slide here because I think for many of us, you will not interact with this kind of information. So I just thought I'd put this here so that we understand that boards are actually different. Not all boards run the same way. There's an issue of the culture that they've adopted. There's an issue of their focus whether it's on relationships or on board tasks. Now, everyone wants the board to sit at professional board because the best practice from Bob Trick, again, who's very, very good at making things simple, says an effective board should be focusing on the outward, the forward, not the past, and should be doing that, looking at how then do we improve performance. So all of these are boards. All of these are boards. But not all boards, a country club board, Kampala club board is not going to look the same as MTN board. It's not. A board of a family-owned business is not going to look the same as one where government has a lot of shares in the board. They are different. And again, this question around what type of board was running the business will come up. And so as it does, it's important for you to understand that depending on the mandate of the board, what you define as failure may differ. Yeah? So that's why I'd included that particular slide, and that is the source. If we could go to the next slide, I'm mindful of time. So let's talk about the director duties, lawyers, accountants, we all know that, we are big on that. That's what's in the Companies Act, right? So on paper, act in a manner that promotes the success, exercise a degree of skill and care, and all that. But on this side is what case law has increasingly said is a recognition that with hindsight, we could all do different. With hindsight, we could all do different. So as we go into what the director's duties are, consider that there is a test that is applied to directors' duties to failure. It's not just as simple as directors were supposed to do X or Y. Next slide. I know I'm rushing, but so duty standard of care, you know, the big one, they should have done. If they did not do, they were negligent or they were outright fraudulent. Yeah. This happens if you can prove. So as an insolvency practitioner, say you're saying, I really believe this board did not do what they were supposed to do. This happens, you could argue negligence or failure to challenge management on proposals because directors are expected to consider the aspects in the bullet. This is what their imprint is. Likely consequences, short and long term. So should I have seen that this would happen? The interests of stakeholders, please notice not shareholders, it's stakeholders, because promoting the success of a company in this day and age is no longer just about the shareholders. By the way, even for a family-owned business, I'll tell you why. Those family-owned businesses have suppliers. When they say we want to close or we want to shut down and they don't have enough to pay some of these suppliers, those suppliers are actually hard done by. So there is a recognition that it's not just the shareholders. There used to be a saying, the business of business is business, which is if I put in the money, I'm the only one you think about. If someone hasn't put in money, they're not an entity at all. Yet we have cases like UTL that are in administration. Why? Why? I know there's some other factors, but a big one also is administration will make sure that employees who haven't been paid, NSSF remittances that haven't gone through, maybe you will be able to give a lot more. So those are the considerations that anyone who's adjudicating, especially a corporate rescue, if you find your matter going to corporate rescue, I would like to suggest we as insolvency practitioners, your approach to building your case should look different. It cannot look the same as if it's an outright, you know, we are hearing an insolvency matter and closing this. Because in corporate rescue, the objective is very different. That is administration and those types of actions. Sometimes you'll even be told, just go and negotiate with the creditors. Surely we can still prolong this and maybe something will come through. So conflict of interest, I think, is clear. I don't need to go through that. Again, the slides will be... So I just wanted to highlight this. I know many of us will have seen it, but it really helps to put the point across on directors and where you might be able to say, look, directors have not done what they were supposed to do. So you had these private equity board representatives who were brought in to actually rescue this business. And they get there, you know, unfortunately for them, these matters were discoverable, WhatsApp messages, the place where you forget to be careful, the email messages, and these revealed that these directors actually knew. So this is the time when it is very hard to argue that there wasn't wrongful trading because they knew. From the messages, it's very clear, and there was a quote, I think maybe I deleted it, where they said, yes, it's there. we are only left with 4 months of cash. But as they were saying that, they were spending on the golf course, keeping employees who were actually being made to water these lawns and all that. They didn't release them, they kept working. And the employees are on record as saying, look, we worked and we still don't have money. And these guys knew a very long time ago that this business wasn't going to work. That is a case where an insolvency practitioner might have a much better chance, because it's very, very obvious that these directors didn't do what they were supposed to do. They sold assets at giveaway prices, and some of them were sold to someone of questionable character. You know, I will not use the word criminal, but, you know, connections to a crime. So even just basic know your customer or know your partner, you know, the question that would be asked. But in this case, remember, even management will be in trouble, would be, did you not do any due diligence before you sold? Meanwhile, the person they sold to is not giving up the assets. He's refused. He's like, that's not my business. So at the end of the day, the stakeholders are clamoring. Creditors want this to go into insolvency, but there's a question around, so what happens for the rest? And that is the reality of the insolvency practice now. It is no longer just about one party. The next one. So, if you go in and you want to build a case, this is what I'd like to suggest, some areas where you could look. It's not exhaustive, but these are areas where you could look. Was there adequate oversight by the board? Was there actually accountability from management? And by this we mean, was the board, and this is where you go to the minutes, did the minutes show that the board was actually asking management, we agreed last time you were going to do X, or you were going to first do due diligence before we do this transaction. Did you do it, or did you not do it? Because those things are supposed to be done. What were the discussions between the board and the shareholders? Was there at any point a sort of alert, a discussion? Governance says there has to be some form of accountability, transparency. If you're holding shareholder meetings and you knew a year ago that the company was in trouble, but you're not saying it, governance says there's a problem there in the way you've run, and that's a good argument for an insolvency practitioner. I think we talked about the risk management systems. Were they approved? Were they followed? These indicators that say, hey, when you reach this amount, stop trading. If they were there and they were brought to the attention of the board and the board still approved, the board has a much harder time justifying that they fulfilled their duty. The next slide. I think there's probably 2 more and we are done. So minutes of the meetings are a good place to check if they are done well, and if they are absent, sorry, maybe just one back. Yeah. If they're absent, that in itself tells you something about the culture, because there should be minutes. The board should have defined what authorities management has and what authorities it has, because the board delegates power to management, and it's supposed to be written delegated authority. It's not just supposed to be, you can enter this contract up to this amount this time, then the next one, oh, we'll decide whether you can enter this one or not. No, that's not how it works. So did the board have information at its disposal? This one comes up all the time in those admin cases. So I would say if we looked at some of these, the next slide, which I think should be the last one, is on risk. And the reason I put this here is because for us as business practitioners, we on our end sometimes we look at the arguments that are being made and we think they are not taking into account a very big reality for business. Business is done in the context of risk. Business is done in the context of risk. That is the reality. The question is, were there clear frameworks and parameters? Now, you may say, that's not my business, I'm a lawyer, you know, again, my argument to you is, it is no longer, the trend is no longer just that you have a good case. The trend has actually changed. So you want to actually understand the context within which these businesses make decisions. I think that should be the last slide. Like I said, I changed my slides because I realized we're going to be short on time. Yeah, I think that should be the last slide. So thank you.
Another round of applause for Rita, please. Thank you very much, Rita. I noted about 4 issues you raised. You urge participants always test assumptions of board members, cultivate a culture of ethical standards, also look at the issues of duty or standard of care, and always remember that it's not just about shareholders, but the actual stakeholders in the business. So to our colleagues here and those online, we've come to the session where we give you a chance to ask questions. We'll do what we did in the morning. If you have a question, you put your hand up. There's a roving microphone. My colleagues Rachel and Hamidu will bring the microphone to you so you're able to ask the question, but there's some microphones on the tables as well, so you can always make use of those. To our colleagues online, I saw we're about 450. You can always type your question or comment into the chat session and it will be answered.
Thank you, Rita, for a good presentation. I know your topic was about corporate governance practices to avoid insolvency, but I would like to ask you to sneak peek into insolvency itself after the insolvency practitioner has been appointed. You know, at that point in time, the board is not in charge. It is the insolvency practitioner. So my question to you is, what principles would you advise that that practitioner who's sitting in the shoes of the board of directors should apply in that period when they are the ones managing or directing the affairs of the business?
Thank you.
Hello, thank you, Rita. My name is Alan Luwaga. I'm an insolvency practitioner. I have a question on corporate governance. Just like the earlier question, you find that you appointed an insolvency, maybe an administrator, but the company doesn't have any clear corporate governance principles in place. The board is not there. Their board of directors, the shareholders, but there's no clear board, there are no minutes, there's nothing. So when you come in, you're charged with the duty of performing, giving the company some sort of rescue, but what is your role in ensuring that actually this company has structures to ensure that there is proper corporate governance in place? The board is not there, there is nothing. Some of the shareholders are actually not the real total beneficial owners of the company, but there is possibility of success of this entity. So what do you do as an insolvency practitioner to make sure that this company lives? Thank you.
Thank you. Any other? Okay, I think Rita, you can take those, and then you just.
Okay, so since they're related, I'll take them in one go. So Olivia, the principles, as I said in one of the slides, the principles are not different. Corporate governance doesn't have different principles because the company is at a different stage of its growth or whatever it is. The principles of corporate governance say that you should still exercise fairness to the extent that you're allowed. I am very aware that this process at that time would be under the regulations and the Insolvency Act, and there's procedures that you need to follow. But in doing so, the principles would still be, was there fairness? Is there fairness in the way you are actually conducting this process, whether it's liquidation or administration? Are you able to actually demonstrate that there is no apparent what's it called, preference for one creditor over another, except to the extent that there's a document that requires that to be the case? Openness and transparency. I know, for example, that there have to be updates, regular updates to the registrar. All of those principles are still corporate governance principles. They are not different. Maybe what I did is, because of time, I took out the slide on what the principles of corporate governance are. It's discipline, accountability, transparency, fairness, and regard to stakeholders. Those are still the same principles, because even you as an insolvency practitioner, you're bound by a certain way of working. So you do not just do things the way you want to do them. I hope that answers your question. It's not a separate code or anything. It just means that you're now in charge as opposed to the directors, so you follow that. And I think, Alan, that's an interesting one. I will not presuppose to say that I have had to run these businesses myself, but I will look at what I learned when I was doing insolvency. as part of ICSA, there was a lot of emphasis on the fact that even in that position, you need to first start by understanding what went wrong. Where did the problem come from? Do you yourself, if you're saying you're going to rescue this company, for example, do you understand what the model is? Do you know who the creditors are? There are things you're supposed to do. Meet the creditors, look at the documents. What went wrong? Where did the problems come from? Is it the best structured way for this business to actually make money or get returns? There's all these rights you have on onerous contracts and preference creditors and all that. Look at those and see what it is you can within your power maybe either avoid or prioritize in order to give a good return. I think the thinking would be that you are a trained practitioner and you understand the best way to go about making this business at least survive or thrive. If you do need to get experts, sometimes you're in an area where you're not really the expert, then you want to actually get the experts to advise you on the best possible model. I think I'd said that in one of the slides, that you need to even understand the model. These businesses are not all run on the same model, and their realities are not the same. Yes, you're in charge. Yes, the directors are no longer there, but you do still have at your disposal the governance framework to help you to turn things around. I hope that answers it. Thank you.
Another round of applause for Rita. Thank you very much for that presentation and for the questions that we've received. Ladies and gentlemen, we're going into our second last presentation. It will come from Mr. Nelson Nerima, and it will be on stakeholder management and communication for effective insolvency. A quick background on Mr. Nelson Nerima. He is a qualified insolvency practitioner and an advocate of the High Court of Uganda. He is a partner at Nambale, Nerima and Company Advocates with wide experience in insolvency and legal practice. He has authored books on insolvency practice in Uganda. He is a board member of Capital Markets Authority, and he's been there since 2014 to date. He holds a master's in law in corporate diploma in legal practice from the Law Development Center, and a Bachelor's of Laws degree from Makerere University. It's my honor and privilege to now welcome Mr. Nelson Nerima.
Yes, thank you so much for the introduction. I also thank the organizers, the Registrar General. Thank you for consistently putting this up without losing the vigor. We are very impressed. I thank the participants for keeping around after the sumptuous lunch. I had been a little worried that after the lunch, the law of diminishing returns would set in. But thank God we are still here. Mr. Antale once again harassed me to make a presentation. I almost declined. So I was saying I almost declined, but this is our country. If we do not serve and build it, no one else will do it for us. I was requested to make a presentation on stakeholder management and communication for effective insolvency administration. Anyone who reads that topic might be tempted to think that I'm going to give you a lecture about communication and administration. But I am not an expert in communication or administration. But I am an insolvency practitioner and also an advocate who has seen not very few cases in my career. So my role this afternoon is to share with you my own perspectives about stakeholder management and communication for effective insolvency administration. It would be useful to start with a brief look at what insolvency law and practice is about. There is a tendency for insolvency practitioners and creditors to think that insolvency is about them, especially individual creditors like big banks. Dear bank, it is not about you. Insolvency is about collective satisfaction of creditors' claim, not a creditor's claim in singular but in plural. Collective satisfaction. So we shall head nowhere if we continue the previous mindset that if I am a receiver appointed by XYZ bank, then my role as an insolvency practitioner is to ensure that the bank recovers its money. Come rain, come shine. That's not the true spirit of insolvency. So insolvency law and practice should provide a mechanism for collective satisfaction. It sounds a little bit socialist, doesn't it? But that's it. Collective satisfaction of creditors' claims when a debtor is unable to pay debts and other liabilities as they fall due. And related to collective satisfaction, it also provides a mechanism of collective execution. When you win a case and you have a judgment award, you execute alone. But in insolvency, it should be collective execution into a pool which is used to settle creditors. So, before we talk about effective communication and stakeholder management, it's important for you, the office holder or insolvency practitioner, to ask yourself, what do you want to achieve? What do you want to achieve? Is it to restructure and reorganize a viable business, i.e. business rescue? You'll notice there is a word there, restructuring and reorganization of viable businesses. Meaning, should you attempt to restructure and reorganize a business which is not viable? I doubt. Another laudable achievement which you can pursue is efficient closure and transfer of assets of failed businesses. So if a business is not viable, you should be honest and conclude it has failed. Achievement of maximum value for the debtor's assets in order to facilitate higher distributions to creditors. When you are doing your work, you make sure you achieve maximum value. If you don't do that, then there are no stakeholders to manage. Then, of course, equitable treatment of similarly situated creditors. It doesn't say equal treatment, but equitable treatment. Timely, efficient, and impartial resolution of insolvency. What you do must be done in a way which is timely, efficient, and impartial. Then, of course, preservation of the insolvency estate. And then lastly, and this is very important for today's topic, managing perceptions. You are Mr. Liquidator, Madam Administrator, Madam Receiver, Mr. Provision Administrator, Madam Trustee in bankruptcy, Madam Registrar General, Mr. Official Receiver, Sijui Manager what? Manager what? Liquidation. What do you call? Mr. Antale, you are Manager Director. Yes, Director Insolvency. All these titles are very wonderful. But how are you perceived? How are you perceived as an office holder? Jesus asked his disciples this question. Mercy, what did he ask? I know you as a devout Christian. What do people say you are? What did he ask them? Who remembers? What do people say I am? And then the disciples answered, some say Elijah, others John the Baptist, others one of the prophets. And then he said, what about you? Whom do you say I am? Who answered? Simon Peter answered that you are the Christ, the Son of the living God. And what did Jesus tell Peter? We shall have another lesson on that. So even our Lord Jesus Christ understood the importance of perceptions. What do people say you are as an office holder? You have to manage it. Do people look at you as a butcher, as a milkman, as an assassin, as a kanyama, like court bailiffs? What is their image? When people hear about court bailiff, what do they picture? In Uganda, what do they call a court bailiff? Wanyondo. Those of you who are fluent in Uganda. In Uganda, you translate the word bailiff as Wanyondo, meaning hammer. Justice Sekana issues an eviction order. The following day, the court bailiff will come with who? Kanyamas and hammers, and they will start demolishing and kicking. That is the image people have. I think as an office holder, you must manage perceptions. That people don't look at you as a bulldozer, as a kanyama, as a butcher, but they look at you as someone who is part of a solution to a problem. What is the problem? Insolvency. What is the solution? Recovery, reorganization, dignified burial of the corpse, etc., etc. They should look at you as part of a solution, not a problem, not a terror. When I was a young boy, very young, the Uganda Army was called UNLA, Uganda National Liberation Army. It was called the Liberation Army, but their image was not of, when you would see a soldier, you do what? You take off. But I think things changed. The way things changed for the army, they should also change for you, dear office holders. You should be looked at as part of the solution. And to do that, you must learn how to manage perceptions. Now, in order to effectively and efficiently manage the process and stakeholders, it is important to understand the motives of the two principles in insolvency, i.e., the debtor and the creditor. Understand the motives. For instance, this debtor who is insolvent, does he or she want to rescue the business or not? Is the debtor merely seeking a dignified end of the business? Sometimes I have seen clients say, sente za bank zannemye okusasula. Sente za bank zannemye okusasula. Naye saagala kunteekamu mu mawulire. You know how to translate that? I failed to pay the bank money, but I do not want to be put in. He's comfortable with the realization that it is the end of the road for his or her business. And it would be somehow okay if the bank quietly solved his property, but not to put him in the newspapers. It's extremely important to him or her. Can you imagine if your in-laws see your house in the newspaper? When you, in December, you staged a very posh introduction with a huge tent, a drone to cover the proceedings. What car do they donate nowadays? You donated a BMW, a Mercedes-Benz, and then a few months later, under instructions of our client, a financial institution, we have instructions. All occupants are required to vacate and allow for prospective buyers to view the property. So if you are advising the debtor, or if you are advising the creditor, who is the bank, understand, what does this person want? Is he fighting the process, or all he wants is a dignified end? Tayagala kumuteeka muki mawulire. That is what we call emotional intelligence. Then you negotiate, okay, if you fear newspapers, let us look for buyers. You also get buyers and bring them. Relating to this, are the debtor's plans realistic? Because as we shall see, a debtor is also a stakeholder. But are his plans realistic? You ask him, sir, this mansion of yours, what do you think is the value? Aha. This house of mine, not less than 3 billion. But this dear stakeholder, is his valuation realistic or unrealistic? The last one is addressed to the creditor, if you are representing a creditor as a stakeholder. Is this creditor seeking recovery, or he has an axe to grind? The reality is that many times insolvency is misused. A creditor is not seeking recovery. He has an axe to grind. I hope everybody here knows what an axe is. Justice Sekana and myself have seen an axe, and we've also used it. But for some of the young ladies here, you might not have seen an axe because you've never been exposed to firewood. At my home, my mother used not to cook on firewood, but I was in a boarding school where food would be prepared on firewood in very huge saucepans, the size of that table. And the boys, one of our jobs was to split firewood. So I know an axe and what it can do. So when they say you have an axe to grind, what picture does it portray? So sometimes creditors have an axe to grind. And there are even cases I'm handling, especially to do with the political motives. Someone has been nominated to contest for parliament or NRM chairman, but you know our Ugandan disease of pull him down, envy, jealousy. You want to bring him down. The man has been owing money for the last 8 years. Then all of a sudden, it is an emergency that the bankruptcy court should declare him bankrupt. So we have to sometimes look at these motives. As insolvency practitioners, as judges, we have to lift the skirt or the veil. Much as all the sections have been quoted, but what is the motive of this stakeholder? We respect you, Mr. Creditor, you are a stakeholder. But before we give you a remedy, what are your motives? I think we have to interrogate that, because many times these processes are misused for political reasons or because someone wants to eliminate competition. They initiate bankruptcy proceedings or winding up proceedings. Now, we can now go into a little bit of detail. Who are the stakeholders? This is a partly philosophical and jurisprudential question. Who are the stakeholders, especially in corporate law. Where is Rita seated? Where is she seated? She has moved out. She has moved out. She talked about stakeholders, that the modern approach is to be as holistic as possible. But this is debatable. It depends on someone's worldview. In corporate law, there are two schools of thought. Those of you who like intellectual pursuits can go and read the authorities on these concepts. There is what we call enlightened shareholder value. This one posits that the ultimate objective of companies is to generate maximum value for shareholders, which is also considered as the best means of securing overall prosperity and welfare. Enlightened shareholder value. The ultimate objective of companies is to generate maximum value for shareholders. And that when you generate maximum value for shareholders, this is the best means of securing overall prosperity and welfare. That when the shareholder becomes rich, it will translate into overall welfare, even for other people. Is it true that if I am a director of a company, or a company lawyer, or a director of human resource, I should be preoccupied with one thing: making profits for shareholders, full stop. I shouldn't care about employees, neighbors, etc. Suppliers, no. Just to make shareholders rich. And if you do that, other people will also become rich. I think this is trickle-down economics. That if the shareholder gets a good dividend, he will buy a car, he will fuel a car, he will build a house, and other people will also benefit. That is how capitalism works. And I think that method has been very successful in countries like USA. There is another approach, or approaches, pluralist approaches. The ultimate objective of maximizing shareholder value will not achieve maximum prosperity and welfare. Company law should be modified to include other objectives, so that a company is required to serve a wider range of interests in addition to achieving shareholder value. These interests may include those of employees, suppliers, customers, and the environment. Is that the Christian approach? Maybe. But it sounds a little bit socialist, if not communist. Dear lawyers present, how many of you think about customers and suppliers when advising your corporate clients? Anyone? I doubt. As an insolvency practitioner, do you think about the neighbors? Before you close down that factory, do you think about the gate man's wife or wives? Do you? You don't. Do you think about the supplier? Dear banker, before you terminate financing for a construction project, do you think about the single mother who sells tea and katogo to the men at the construction site? But this is what the pluralist approach says. You think about the wider category of stakeholders when making decisions. So as an insolvency practitioner, it's up to you to determine what approach to take. To focus on the interests of your client only, or to always be mindful of the interests of other stakeholders. But it is not my job to direct you on what approach to take. My role this afternoon is to help us to broaden our minds as to the possibilities out there. And it is up to you to determine what approach is best, also depending on the wishes of your client. There are some clients who can sack you the moment you begin talking about environment. Not so? Hey, that you woman, have you been bribed by my enemies or what? That you know, sir, now pumping sewage into the wetland is not good. Now if you cut down these trees, we might have a desert. You might be in trouble with some clients. Then others might be willing to listen. So I don't want you to be a wiseacre. Sometimes one of the reasons why we don't progress in our professions is we become what? Wiseacres. That, oh, Mr. Nerima talked about pluralist approaches. Then you begin telling someone, now, sir, think about these women who are selling katogo. But now, surely, how can you buy someone's kilo of coffee at only 2,000 shillings when a bar of soap is how much? Is it a bar? What is this one called? What about after cutting? It's a piece. So a bar is now 7. So there are some clients, if you begin telling him that now it is unfair, a farmer has grown his matoke, he has suffered, and you're offering him only so much. Yet soap is increasing, the price of sugar is increasing. We have to consider all stakeholders. It's not about only profit. You will be in big trouble. Some of these theories are good for you as an intellectual, but please know where to apply them. Otherwise, you will not get clients. So some things you keep them to yourself. Society cannot change overnight. It changes slowly by slowly. Even these theories of corporate governance, you cannot apply them 100%. The world changes slowly by. So I don't want you to become wiseacres. You go and start lecturing people because you've heard me or Rita tell you certain things. You will be in big trouble. I will be telling you about my views on corporate governance later on, basing on my own personal experience. But the truth is that commodity prices are increasing. That's the truth. But I think for most of the people in this audience, you are not feeling it. Because you just go to the supermarket, you don't even notice. Do you even notice the price of sugar or soap? You just tell the lady at the till how much. Nowadays, we don't even move with cash. How much? You swipe. But many of our people out there, things are not okay. But we have to think about them as we do our work. But Jesus told us that the poor will always be there until he comes back. It's true, the poor will always be there. You cannot eliminate poverty. You can't. If there was no poverty, would you be having servants at your home? So poverty is a reality, but it is important that we are not deaf and blind to the reality of people who are less fortunate and to take into account their interests when we are doing our work. We've already indirectly looked at stakeholders, but we can now look at more of them without going into details. Stakeholders in an insolvency, secured creditors, and in Uganda, most insolvencies have a secured creditor, usually a bank. Secured creditors, unsecured creditors. The debtor himself or herself, is a stakeholder, employees of the data, consumers or customers are stakeholders. Everybody here has his or her brand of soap. Not so. If that soap company closes down, you will be affected because you have your favorite brand of soap. Not everyone, most of you, especially the ladies. For me, I don't have a particular brand, but most people have. I use this soap, I use this toothpaste. So if the manufacturer becomes insolvent, you are a stakeholder because you will be affected. And neighbors, stakeholders, they might be. That woman who sells katogo and black tea to the builders at a construction site, does she come from Mbarara to sell tea to this construction site, or she comes from within? From within. So sometimes you find that a neighbor is also a stakeholder. If there is a big supermarket in a shopping mall, can the small businesses in the shopping mall survive if the supermarket closes? Can they? No. You've heard of what they call an anchor tenant. There is an anchor tenant, then the anchor tenant has neighbors. If the anchor tenant collapses, the neighbors will have no business. Family of the data. If I am declared bankrupt, are there stakeholders behind me who will suffer? Yes. Like my wife, or your wives, as the case may be, your children, your husband, your mother, your father. Does my mother consider my financial capacity the most important aspect of my life? To her, what is most important is that my son is a what? My son is a lawyer. That is very important to her. So if I became bankrupt, her problem would not be money because she can get money from other sources, but her problem will be the embarrassment that her son is no longer practicing because of bankruptcy and he has gone back to the village. So when we are doing this work, we shouldn't do it in a vacuum. We should appreciate the circumstances of our society, that even a family can be affected by the decisions we make. And then, of course, the economy as a whole is a stakeholder when you are making decisions. Now, when you have different stakeholders, naturally, you will have their interests compete with each other. You know the famous concept of priority of debts. You have the secured creditors, the unsecured creditors, the preferential debts, the surplus assets. If you are a receiver, do you take priority over the secured credit? That is a discussion for another day. So these interests compete. Is it in the interest of the economy for inefficient farms to be kept alive? That is also a competing interest. That we are preaching the gospel of business rescue. But as we've seen, the economy is also a stakeholder. Do we have an economist here? An economist? I'm sure we have, but they are shy. In economics, there is that concept of efficient and inefficient farms. And if a farm is inefficient, it will close down. And then efficient farms will grow and occupy its place in the market. That is why many people in the US were against bailouts of those big banks. That if a bank is in trouble, allow it to close. And then banks which are more efficient will come up. That's a debate. Should the receiver or liquidator focus on the interests of his principal or be concerned with the interests of all stakeholders? In Uganda, as we've seen, the culture is you focus on the interests of your principal. If you don't, the bank will withdraw instructions from you. They want a lawyer who is aggressive. You go with a kanyama, head to the hardware, buy paint and a brush, go and write on the man's gate, bank property, not for sale. That's what they want. Don't think about his mother who might suffer a stroke. Don't think about the wife who is sick or who is pregnant. Your interest is recover bank money. Even in all meetings, you are saying one word, bank money, the bank money. The bank wants its money. Those are competing interests. What is more important, the bank money or someone's pregnant wife who has high blood pressure? Which is more important? Which is more important? Even if you are the bank receiver, but these interests many times compete. I was told of a story of a bailiff who got a warrant of attachment for a pickup. He looked for the pickup in vain. I think the owner hid it. Then the owner died, and the pickup was used to transport his body to church for a funeral service. And this man was tipped off that the pickup is at the church. And he arrived as the body was being loaded onto the pickup to be taken for. This man produced his warrant of attachment. The coffin was removed from the pickup, placed down, and he drove off with the pickup with his kanyamas. Is what he did legal? It is legal, but is it in the interests of all? No. So sometimes we must have a human heart. I would have given another example, but I will be in trouble. I won't give it. Now, how do you manage these competing interests? Sometimes, as we've seen, the creditor wants to send a message. He's not intending to recover, but just to send a what? A message. So after the message has been sent, please cease fire. If your creditor principal is willing to consider interests of other stakeholders, you can encourage him or her to take a haircut. You'll go and read about what we call a haircut in restructuring. Should the creditor count his losses and move on? Sometimes this one can be done. That you declare that it is a bad debt, write it off and move on. If it is a restructuring plan, what effect will it have on employees, suppliers, community, etc.? What you are pursuing, is it legal, or you should ask yourself whether it is legal and fair to all or most? Because many things are legal, but they are not fair. Now, briefly about information and communication. How does an insolvency practitioner share information with stakeholders? I won't go into the details because you are all experts. You know the provisions of the Act and the regulations at your fingertips. You know the filings with the official receiver. How many people actually go to read them is another question, but you do the filings. You do the Gazette notices. How many Ugandans read the Gazette? Very few. Newspaper notices, preliminary reports, interim reports, creditors' meetings, producing reports at your office for inspection. Then there is that one, public relations. I think public relations is extremely important. You may not have a public relations manager, but when you are doing an insolvency, make sure you are adept at public relations. How do you communicate information? How do you talk to people? If you are a liquidator or an administrator and someone gives you a call, how do you explain to them? Do you talk to them in a rude way, or you explain in a polite way? I receive many calls. Excuse me, sir, I am so and so. I supplied such and such a company where you are a liquidator. I would like to know when I will receive my money. You don't say things like, there is no money. You listen and then you gently explain to the person that there is actually no money, but efforts are being made. Maybe in future something might become available and we shall call you. Do not shut off a person rudely. If you've been appointed a liquidator or receiver and you are going to lay off workers, how do you tell them when you are addressing them? Some things are not taught in school, but you must have emotional intelligence. Like you don't go and say, dear workers, for some of you who have been extravagant, spending money anyhow, failing to save, you are in trouble. Those of you who are in the habit of marrying many wives, I don't know what you are going to do, because the jobs are finished. I pity you. How do you inform them that the jobs have come to an end? That is what we call public relations. Even when you go to evict me from my house so that the bank can auction it, how do you do it? Public relations. Then relating to that, mind your language. Don't be rude. Don't be arrogant. Even when you want to say something pleasant, please sugarcoat it. Managing stakeholders can be very difficult, and sometimes you cannot manage on your own. The law has escape routes. Where you find that something has become very difficult, make use of the avenues in the law. Committee of inspection, go and read about it. Court supervision. My Lord Justice Sekana recently gave relief to a certain administrator where you feel that the interests of stakeholders are competing and the thing has become too hot. Take it to Justice Sekana. And then you say, this question was determined by the court. Don't think that you are all wise and you can manage every competing interest. You can answer every question. For some things, make use of court supervision, make use of the power of court to determine certain questions. And then also, court can help you to review or fix your remuneration. And then you will say, the money I have been paid was fixed by court. Now me, I worked for this company for 20 years. How can you give me terminal benefits of only 2 million? When you, the receiver, you've received 500 million. So, madam, the remuneration was fixed by court. And as you know, we all have to obey court orders. Practical challenges when managing insolvency and stakeholders. Absence of corporate governance. This one, a lot has been said. There is one thing in the law and there is another thing in reality. In most companies, there is no corporate governance, no functional board, no tenants agreements, no employment contracts, nothing. Even when the board is there, it does not work. In most of our companies, things are extremely informal. No clear structures, decisions are made informally. And there is a lot of shadow directors and de facto directors in our companies. People who are not actually directors, but they make decisions. You ask the founder and investor, he will tell you, you ask Hajat. You ask who? Hajat. Hajat is not a director. She's not a shareholder, but the entire corporate governance of the company is vested in who? Isn't it the truth? Yes, ask Hajat. Spouses manage companies even when they are not directors. That's the reality. Employees. Sometimes you find there is a board, but the company, all decisions are made by a particular employee. It is a real estate company, an arcade, but there are no tenants agreements. But some young lady knows all the tenants in her head. The rent they pay, when they last paid, that is their system of corporate governance. Sometimes it is a lawyer who manages the company. Even me, there are some clients of mine who ask me to make decisions which should be made by the board. Someone takes a property to the company, this is a good property to buy. So you buy this property, then you say, go to my lawyer. Mr. Nerima, I'm sending to you someone who is selling a property. You advise me. But Nerima is not a real estate consultant. He's not a business man. So you find Nerima is making decisions which should be made by the board of directors. But I won't do about being a wiseacre. If a client trusts his or her lawyer to make for him decisions, whom to fire, what property to buy, what property to sell, which wife to marry, which wife to divorce, which boyfriend to accept, which boyfriend to chuck, all of those decisions, you are the one making them. Then you begin to gezi. Dear madam, according to corporate governance principles, you must have a functional board which is accountable. You must study the audit reports. You must manage risk. It is good to educate your client slowly by slowly. If you do it very quickly, they will say you are a wiseacre. So we who are educated, let us be knowledgeable about these principles, but let us not stampede our clients because they are at 0. You are here at 9, but your client is at, you begin telling him about corporate governance, functional board, he will say, I think I can't manage this lawyer. It is like if you want a person to get saved and he has been smoking and drinking for 30 years, and then you preach to him, unless you stop smoking and drinking and womanizing, you are going to hell. Are you realistic? Leave him to come to church as a womanizer, as a drunkard, as a drug abuser, but let him come. Slowly by slowly, he will do what? He will change. So let us give our clients time. If your bank client is greedy, they don't want to hear about other stakeholders, it's okay. For now, let them be greedy, but let it be work in progress. Slowly by slowly, we shall reach the promised land. Of course, there are other challenges. Companies don't file returns, so you don't have information. Company is over-reliant on the founder. You are an insolvency practitioner, but you have no experience in that particular business. Some stakeholders are temperamental, especially employees or former employees. They can even bring a dead body to your office. You've heard of those stories. Yes. Then some sectors have a very negative outlook. So if you are to carry out business rescue, it might be particularly hard. Sectors like education, hospitality, etc. The property market is subdued. Valuation reports are unreliable. Then lastly, the problem of secured creditors. They have too much power which leaves you very little room for maneuver. That is the end of my presentation. However, so what is the time? 4:15. Now, I have a case study. If we do that case study properly, there might be no need for questions or discussion. Can you allow me, sir? Or if there are questions, they might be very few. We have a case study here. You project that case again. Have you heard about Purdue Farmer? Insolvency practitioners should have heard about this. In Purdue Farmer. So we are going to use this as a case study on how to manage stakeholders and how to navigate competing interests. Afterwards, you will go and Google about Purdue Farmer. I don't want to use a case study about Uganda because some of these cases are still alive in court. Purdue Farmer is a company founded by the Sackler family in the US. And it makes pain medicines, otherwise called opioids. There was overprescription and abuse of opioids in the US, which led to thousands of people in America becoming addicted and thousands dying. And since America is a highly litigious country, Purdue Farmer was faced with thousands of lawsuits in respect of personal injury, deceptive marketing, etc. As the crisis worsened, what did the Sackler family do, the owners of the company? They began to withdraw billions from the company. In the period 2008 to 2017, billions of dollars. Half of the money they invested it in offshore companies owned by themselves. Other half of the money they put it into trusts in locations like New Jersey. You know why? Having spirited away billions in offshore companies and trusts, they now filed for Chapter 11 bankruptcy in New York. And they got bankruptcy protection. And they prepared a plan to settle the indebtedness of the company because it was facing thousands of lawsuits. They called it a plan of reorganization. 95% of creditors voted in favor of the plan. What did the plan entail? The Sackler family would transfer billions of dollars into a trust to fund treatment of opioid addicts and related activities. And they would transfer the entire Purdue Farmer shares into that new company. From liability, then we give billions and our company to a new company to handle the crisis. The bankruptcy court in New York approved the plan. However, the attorney generals of some states in the US opposed the plan. 8 states. They were not happy that the Sackler family, who had siphoned billions from the company, were going to walk away scot-free in exchange for donating just part of their loot. So these attorneys general filed an appeal to oppose the order of the judge which had approved the restructuring plan. In December 2021, the court set aside the approval of the plan, giving different reasons which I want to go into now. The ruling is 142 pages. Those of you who are interested can approach me, I will give it to you. But the court said, Judge McMahon, she said, that in her view, the lower court did not have power to grant a release to this family, because the principle of bankruptcy law is that a plan binds creditors and debtors. If the Sakala family are shareholders in Paddy Farmer, so Paddy Farmer is the debtor, the victims are the creditors. So who are the parties? Paddy Farmer and the victim. But now the restructuring plan was saying that the shareholders of Paddy Farmer, who is the Sakala family, are also released from liability. And the judge said the family are not the debtor, so you cannot release them from liability. And she vacated the order which had approved the restructuring plan. That was in December. But in March this year, a mediator reported to the court that a new deal has been reached. The Sakala family is going to contribute an additional $6 billion, and in exchange, they are going to continue to be protected from liability, personal liability. The Sakala family have also refused to apologize. That was very important to them, that they did not want to apologize. So instead of apologizing, they issued a statement of regret. When you are poor, you think that money is most important. But for people who are rich, the issue is not money. They would rather die than apologize. There are so many museums, lecture halls, roads, universities named after them because they have been big donors. So to them, apologizing is out of the question. So they have not apologized, but they have offered a statement of regret about what happened. Parents whose children became addicted to these painkillers are happy that more money will be available, but they are sad that the Sakala family, which promoted painkillers and led to addiction, will not be liable to civil action. Now, you've listened to this story. As a case study, can you consider who are the stakeholders in such a problem? Assume you are a mediator, a provision administrator, an administrator, or even the official receiver. Who are the stakeholders? What are the financial interests of the stakeholders? If your daughter became addicted to painkillers and she's in a wheelchair and cannot do anything for herself, do you have a financial interest in this insolvency? Do you? Or your daughter? You might have, because for life she will need help. But are there non-financial interests of stakeholders? Supposing your 15-year-old daughter died as a result of addiction, do you have a financial interest in this insolvency? For you, what you have is just emotional pain. You want to hear the manufacturers apologize and saying sorry. And lastly, were the stakeholders in this insolvency managed or mismanaged? So when talking about managing stakeholders, it is always good to look at different insolvencies. Read what happened, why it happened, and determine what mistakes were made, what things were done right, how can improvements be made in the future. Near our home, we have many bankruptcies, we have many administrations, we have many liquidations. If you see any case decided by court or a case being filed in court, as a practitioner, don't read it like a novel, because we have that disease in Uganda. We read things as if they are novels. Even the Bible, we read it as if it is a what? A novel. Read this case and look out for certain things. Who are the stakeholders? How were they managed? Because at a certain level, you are not looking to educate yourself about the meaning of insolvency or the procedure of liquidation. You know it. What you want are the practicalities. How do I manage stakeholders? How do I communicate? In this particular insolvency, why did it end up in court? What mistakes were made? How do I make sure that when I'm doing my own insolvency, I will not make the same mistake? As a registrar general, how did this mess arise to reach court? As a registrar general, how do I ensure that a similar problem does not end up in court? That is how we should approach. Don't look at cases as curiosities or as academic studies. Utilize them to broaden your mind and to help you to improve how you look at your work and how you can improve your work. Once again, I thank you so much for listening to me. I'm not very keen to answer questions, but I am very much interested in having comments and further contributions. God bless you.
Thank you very much, Councillor Nerima, for that in-depth presentation. I know you said you're not interested in questions, but I have one question. It's been pending for a while as you were presenting. Daniel Nasasira asked, if the financial institution does not publicize the sale, won't it be subject to insider dealing or crime or unfair dealing in collateral to the detriment of potential buyers in the public that are not aware of the sale?
I didn't say don't advertise. I was just warning about understanding interests and motives. So if the data is willing to have his property sold without an advert, is it illegal? It's not. If a person says, I don't want embarrassment, and is willing to do a private treaty, you cooperate with him and sell privately. It's not a must that you must put a picture of his house and his name in the newspaper. That's what I'm trying to say. That where it is possible to avoid embarrassment with the consent of the data, do it.
Okay. Do we have any questions from the audience?
Especially contributions.
Questions and contributions from the audience? My colleague Rachel has a microphone, so if you have any question or contribution. Okay. Looks like your presentation was wholesome, but there's a comment here. Somebody called Andrew Wambi. Mr. Nerima, your books are out of stock in the bookshops. Please advise on how we can get a copy. Say the books are out of stock. So you can always advise.
It is unethical to use Madame Massey's conference to advertise books. We can talk about that outside.
Okay, thank you. I'm sure Andrew Wambi, you've heard that. Thank you again, Mr. Nerima, for that presentation. Can we just give him another round of applause? Our next item on the agenda is remarks. Will be remarks from the Association of Insolvency Practitioners of Uganda, and it will be, the remarks will be delivered by Dr. Albert Otete.
Good afternoon, everyone. Can you hear me clearly, those who are online? My name is Dr. Albert Otete. I'm certified public accountant by profession and a member of the Association of Insolvency and Business Restructuring Practitioners of Uganda. The president gives his apologies. He could not come and attend, so he delegated this responsibility to me, and I'm going to read his remarks at this particular conference. Of course, he say all protocol observed. We know that there are a number of people here of different positions. Some of them may have left, so I cannot tell now who is still around, but all protocol is observed. So we as the association, we are happy to be attending and also giving closing remarks at the Insolvency Conference, which has been held under the theme, Emerging Trends in Corporate Restructuring in Uganda. In giving these remarks, kindly permit us to say something about our association. The association is a multi-professional one. You heard about the type of professionals who are allowed to practice. And this profession seeks to advise, offer training, and management for the improvement of services offered by insolvency practitioners in Uganda. It is voluntary, non-partisan, non-governmental, and without any religious affiliation. So just to remark that we have lawyers, we have accountants, and also secretaries. Our objectives are to promote, advance, protect the interests of those involved in the insolvency and business restructuring industry in Uganda, to promote, support, oppose, or propose changes in the laws and regulations prevailing in any part of the world, and to promote contact, discussion, and exchanges of views among and between persons engaged in the practice. Membership to the association is based and is open to all practitioners as recognized under the law, which is Insolvency Act of 2011. So there's a governing council at the association at the moment, and these people are serving in a voluntary capacity. Very soon there will be elections. But for now, we have Mr. Isaac Bakayana as the chairperson. He's the one who was supposed to make these remarks. He's unable to attend today. We have Mr. Kenneth Makanga, CPA, vice chairperson. We have Mr. Andrew Munanura. This must be a lawyer. Rita Baguma Birunji, also lawyer. Julius Tumuhimbise, did I see him around? Is he around here today? So these are the 5 members. And that means that you as practitioners, in addition to registering to be a member with the URSB, you can also stand for these positions when the elections are opened. It's a young association, duly established under the laws of Uganda. It is registered. There's a constitution, and even there are those who signed the initial constitution. And we welcome all of you to join it and grow and make it a contribution to the insolvency practice. I'm not sure how many there are now, but we expect to see more and more members. As an association, we are eager to participate in any discussion on insolvency in Uganda and elsewhere, with the idea that we assist entities survive. So as already been mentioned here, the word is insolvency, but there's also business restructuring and make a contribution to the economy. Because if the business is alive and restored, it means that even all those stakeholders we have been talking about, like employees, suppliers, are also going to benefit from the survival of that particular company. But if it is closed, definitely those ones also are going to lose out, including government of Uganda. We do not see our role as undertakers. I think that word was used in the morning. to put companies or other business entities to their resting place, as often but mistakenly associated with insolvency. So who do they say you are? I think that was the question which I asked. We are not undertakers. We are alive to the young economy that Uganda is, a growing economy that our economy is, and the various steps that are being taken by the government and other players to grow the economy. So as we also saw in the morning, that really we are also interested in making sure that these companies are actually existing. Therefore, our role that works with both government and non-government players is to take the businesses further ahead. So given the registers which Ursb is talking about, we as practitioners, we are having an opportunity really to provide many solutions to our clients, to find solutions that ensure survival of entities rather than bury them. Solutions that contribute to the employment. So it's very clear here. Employment, revenue generation, widening tax base, and including all in our economy. So sometimes we are talking about only business entities which are profit-oriented, but we can also provide advice to individuals and also other non-governmental entities. So we are therefore glad that URSB has always viewed us as our association as business partners and always call on us to participate in its activities. For that, we are grateful. We are happy to have participated in this conference and hope that the fruits from it are realized in our entities and throughout the country. Thank you very much. So I don't know whether there will be any questions for me. I was just presenting on behalf of the association. So do I remain at the podium or? Okay, thank you very much. And hopefully the MC will tell us what else is coming up. So stick around.
Thank you very much, Dr. Otete. What's coming next is our closing remarks from the Registrar General, Ms. Mercy K. Kanobisho. Just before the Registrar General comes, in your folders there are some evaluation forms. We'd ask you to take 1 or 2 minutes of your time, just fill them in and give us feedback on how you think the conference has gone to help us improve on future conferences. I would now like to invite the Registrar General to give us closing remarks.
Dennis, I thought you were a gentleman, you'd carry me to the podium, but the perceptions and the things around insolvency are still in your mind. Good afternoon, colleagues. I see the numbers have gone down, but I'm informed that the online team is still on, and I would like to take this opportunity yet again to appreciate all of you for remaining patient and staying behind physically and online. And this is in your own interest to learn new things, to learn emerging things. I was just seated there listening through the presentation since morning and feeling sad for those that have not had the opportunity to attend this conference, because I know that all of us are going to go with new knowledge. All of us have reset. All of us are going to apply things are different. From the topics of discussion, from the presentations that we have had, the statements of the opening ceremony, the presentation by the Honorable Justice Musa Sekana, who has just stepped out, the presentation by Mr. Kabito Karamaji on the East African context, the presentation of corporate governance by Rita Kabatunzi, the presentation by Mr. Nelson Nerima on stakeholder management, and we've had a benefit of most of us going through his hands, his academic hands. Mr. Nerima, thank you very much that your lessons will remain impactful and you speak reality. And these are things that happen indoors and outdoors, just within us, our spaces. And thank you, Doctor, for representing the association. And to you all that have been patient, I know as we step out today, we have been vaccinated since we are speaking the language of vaccinations for the last 2 years. We have been vaccinated since morning and since yesterday with the judicial officers. This time not with AstraZeneca. Maybe we can call it insolvency knowledge, and will not remain the same. I want to thank you very much, and every time we call on you, kindly respond, but let's also put what we have learned in practice as we manage stakeholders especially. And as Mr. Nerima presented, I know many of you are thinking of what the past mistakes that we have done, or you have done, and the emotions that you have caused and the pains that you have caused in your work. But of course, as Mr. Nerima stressed, do not be a wiseacre. Use your emotional intelligence to do the right things at the right time, also within the right environment. I wish you all the best, and I hope my team can guide on the next program. This was the 5th conference, and we look forward to seeing you in the 6th conference, Insolvency Conference. And once again, my team, kudos, the URSB team. You've done great. Thank you.
Thank you very much, the Registrar General. Dear participants, we've come to the end of our proceedings for the day. I've been informed that all the presentations will be available on a flash disk that you'll be handed at the back of the tent, and all other administrative issues will be handled at the back of the tent. From the entire team from URSP, we'd like to say thank you again, and we look forward to having you again at the next conference. Have a good evening.
Business opportunities and start afresh. URSB offers you options of corporate rescue and liquidation or winding up of your company. We help you minimize the risks to your personal assets, estate and credit by providing satisfactory advice on the next possible options in such a scenario. For more information, visit our offices located on Plot 5, George Street, Georgian House, or visit our website at www.ursb.go.ug or call our toll-free line on 0800 100 006.